Hello, adventurer. It's good to see you. You have made it to the morning grind.
Welcome, welcome.
It's the live stream at the beginning of the Geekverse, where we talk about all types of topics in geekdom, gaming, and fantasy, with an emphasis on being constructive and creating the things that we want to exist in the world.
It's all on the grind, Sizemore. Can't be too fine, can't be too coarse.
That's exactly right. There are a lot of adventures to be had today. Dungeons to explore and monsters to slay, and who knows what a random encounter might send our way. That's why we have to prepare, so settle in now for the morning grind with your favorite beverage in hand.
Tea? Or maybe something a little stronger. I've got a few bottles of the old Wynyard left.
Whatever you want. Pull up a chair.
Dude.
If you're feeling fancy, how about a cappuccino? Or a frappuccino? Or how about an espresso?
Just tea, thank you.
Sounds good to me, Gandalf. Whatever you want. I'm just glad you're here.
Everyone is welcome. You can just watch if you want. You don't have to worship anything you don't want to worship.
Thank you, Mike. But be forewarned.
Sometimes we get really strange characters around here.
Wait, what's that you say? Why can't you come and be a part of the stream?
My wife would disown me.
Oh no, I bet she'll be fine with it. Come on in.
Am I scared for my safety? No.
What are we supposed to do?
Everybody do the secret handshake.
Secret cultist handshake.
Oh, now do wizards who love each other.
Yeah. This, my friend, is a science.
I still don't have gifts, but it's fine.
It's all on the grind, son. Can't be too fine, can't be too coarse.
Dude, this would be a sick place to bring the band.
Indeed it would be, Dave. It really would. I'm seeing more people coming in. Welcome. Glad to have you here. Oh, look, here's someone new.
Is this the cultist meetup?
Yes it is.
Come to hang out? Please accept me. I have nothing else.
Okay, we accept you. Everyone's welcome here.
Brought some snacks.
Well, that makes things even better.
You want some coffee?
I don't drink coffee.
You sure? It's cultist coffee.
What makes it cultist coffee?
I'm a cultist and I'm drinking it.
Oh. Then I'll have some.
What exactly is going on here?
I'm seeing more people coming in. Welcome, welcome. It's so great to have you. Oh, and look, here comes another stranger.
Can we help you?
Yes, fellow cultists. I could really use some food.
Oh yeah? Welcome. We have donuts.
Oh, it's me. I'm glad I'm here. I'm sure you have a few questions for me, though.
What's your name? Who do you work for? What god do you worship?
Great questions, Rob.
I'm Steve King, and I worship Nyarlathotep.
No, not really. I'm just Heath, and I won't be worshiping anything this morning. But I will be your host. Welcome to the office. We're going to have a great time. I've got my coffee ready, because now it's time for the morning grind.
If you could become a fish, that would be amazing. Then I could command you with my mental fish powers.
Hello, everyone, and welcome to this special live stream at a different time here, but I thought it was important. Did people see the interview with Ryan Dancey? I was watching, and I thought it was amazing. I thought it was fantastic. A lot has been going on over here. We had the stream and the raid last night. There was a 7 hour and 20-minute live stream last night that went late into the wee hours of the morning, and then the morning grind this morning, and then right after the morning grind, this dissertation. I wanted to get into this dissertation that was written on the OGL to find out if there was information in it that we really need to extract. So I was looking at that. I made some breakfast after the morning grind, and I was sitting there eating breakfast and trying to take notes on this dissertation. And then it was the case that the interview on Roll for Combat Live came up, and I went, oh yeah, that's coming up too. So I was trying to take notes and then watching that, and I figured it'd be a good time to go ahead and do the live stream on that subject, and then I'm going to take the rest of the night off. Right. So rather than doing the wind down live stream tonight, I thought we should go ahead and talk about it while it's fresh on my mind, and then, like I said, I'll take the night off. Hello, everybody. Hello. Glad to see everybody here. Barbsy, welcome, welcome. Stray, see you here. Draco, welcome, welcome. Tough Years and Vision, wonderful. Good to see you all. Yeah, Andrew says, yeah, it was not intended to be that, but it's kind of fun. You should see if you look into that live stream. I think starting at about the 3 hour and 20-minute mark, that's when MC Tune, we were rated by the Tune crew. It's a lot of fun. It's a lot of fun. And then I was interviewed over there, and you could watch it on this stream because it was streaming in both places. It was really great. Yeah, Mark says, really informative as to the origin and intent of the OGL. Loved it. And the OG dissertation, the OGL dissertation is epic. Yeah, we got dumped on with that live stream and with this dissertation. Really a ton of good, high quality information that goes on here. I feel that in my mind, the issues that all of a sudden got raised, like, wait a minute, are there suddenly issues that we've got to deal with as far as the OGL goes? Between those two things, and especially the Ryan Dancey interview, to me, it kind of resolved it. You know, it kind of resolved it. So yes, please do hit the like button. Oh, The Cultist was very good. So good. Very impressed. Barbsy says, well, I'm glad you enjoyed it. I'm glad you did. The Cultist is our comedy web show about Lovecraftian cultists, and they do play D&D. They're role-playing D&D cultists, Cthulhu cultists in the modern world. So, and that's here on the channel. Each episode's like 8 minutes long, and we've got 2 seasons. So please do check out The Cultists. Oh, hey, Mark. Mark's here. So Mark was one of the co-hosts, of course, on the Ryan Dancey stream. So, yes. Well, thank you very much for hosting that. Thank you so much. I mean, that was just an absolutely incredible thing to be able to get and to talk to him about. And I think a huge landmark in the community, the whole community, because of the importance of the OGL and especially what's going on right now. Yes, here, Roll for Combat. If you're not following Roll for Combat, you need to watch that stream first. Because I mean, I highly recommend you watch that stream after this one or right after that. If you're interested in tabletop gaming and Dungeons and Dragons at all, regardless of the OGL situation, we're all concerned about the OGL situation. But that stream was just incredible. It was a fantastic interview. Let's see. Anything else? Thank you. All right. So, okay. So my thinking was that after concluding that, because one of the initial questions that I had when I was once all this came up, and what I thought was the elephant in the room was this idea that, wait a minute, what is happening here? Is it possible? Like, how is it possible, or is it possible that there has been some kind of flaw in the OGL from the beginning that no one has noticed over the past 20 years? Or was there was there something that was slipped in by Wizards, which was owned by Hasbro at the time? They said that. I had forgotten that. I wasn't clear on the timeline on that. But they said on the stream that Hasbro was even owned Wizards when all of this was done. Was there some type of super tricky thing that was slipped into the OGL from the very beginning to enable something like this to happen that nobody noticed over the past 20 years? Or was there a flaw that something was not right about it and we just didn't notice by accident? That was the case, and we just didn't notice. And it seems like between all of this stuff that's been going on, because I've been trying to track down, I was putting notes in the Discord server. I guess I should put out the link to the Discord server. I was putting notes in the Discord server on the issues that I thought were the ones that needed to, major issues we were having, which involved revocability, basically, authorization, and perpetuity. And that does seem to make sense, right? If I give you a perpetual license, well, how long do you have that license? In perpetuity. That seems like the answer there. And it seems like some people were saying, that seemed to be implying that the word perpetual seemed to mean something a bit more like indefinite. If I give you, here's a license for an indefinite amount of time, if I'm giving this license to you, in perpetuity, is different from saying I'm giving you this license indefinitely, right? So if I give you this license indefinitely, is that a short time or is that a long time? Well, I don't know. It's indefinite, but it's an indefinite amount of time. But perpetual is much different from something being indefinite. And so it seems like that's been kind of cleared up there. That clearly I was completely satisfied that Ryan Dancey, when he was talking about this, that the OGL was intended to be exactly what we all thought it was. It was intended to be exactly what we have all thought it was for the past 20 years. And it actually is what we think it is and have thought for the past 20 years. So that was my big takeaway, that it's not the case that there was this weird elephant in the room that nobody noticed for 20 years. It is intended to be what it is and what we thought it was, and it is that. Is that kind of other people's thinking as well? Well, and right, exactly. So that seems to be an issue there as well. Judy, you got this, because that's what I was trying to track down, and if necessary, documents. And I put some notes in the thread on the Discord server that people were bringing up in the comments, because I was seeing comments go by, involving that and things like that. And it seemed to be that, yeah, if this word revocability were something that might not even have been used around the year 2000. And there was a lot of conversation about that the word perpetual is sufficient, basically. I mean, that's just legal language at that time. And there wasn't I like one commenter, I forget who it was, but I got it over here, who was saying that there wasn't some legal magic word that has to be in there, and the magic word wasn't there. And so, something is invalid. That seems to not be the way that it is at all. And I said that we should be able to track that and document exactly what you're talking about, Judy, that you should be able to track down, academically in case law and stuff like that. And, I'm an academic or came out of academia. So, being able to trace that down if we needed to seems like something that would just be like rudimentary. If somebody's saying, no, it says this, but that was not, a terminology and phrase that was not in use at the time. That was up for consideration. And if we need to track that down, then fine. But it seems like it does what it was supposed to do when it was there. Right. Gognard Wizard says perpetual doesn't mean indefinite. However, perpetuity is defined as a thing that lasts forever or for an indefinite period. Okay. And actually, in this dissertation, it does talk about perpetuity with regard to copyrights. And there's some additional phraseology there as well. So that was my big takeaway. And so in a sense, that means that I think it's kind of resolved. Being that now, it doesn't mean we don't have an answer from Wizards. And I believe we just still don't have anything further from Wizards. I was checked their Twitter account before I came back on, because the D&D Beyond Twitter account had said there would be something new coming, but don't know how soon that is. So I think there's nothing else there nothing from their end. But in my idea here has been primarily to make sure that all of my friends who have been publishing under the OGL with certain understanding, a lot of them think, oh my God, is the sky falling? Is there something I didn't understand? That seems to be clear to me, at least in my mind, is resolved that that's not the case. And so I want to be sure, insofar as I have any influence or power, which is not much, but that the OGL 1.0A stands so that everybody can still sell their books, everybody can still publish new books, everybody can do exactly what they were doing, and publish new material and continue to expand the 5e rules and with modules and everything like that, and just keep going exactly like we were doing, regardless of whatever Wizards may choose to do with what they're calling 1 D&D or 6th edition. Now, if that's got different rules, if it's got a new license, new rules as far as the game goes, a new license, whatever, okay, but then we don't have to swap over. But maintaining what we have, I think, is the most important part. And it seems like it would upend so much, being that this you track this down through different types of the open licenses in software. It seems like if this was some major change over here, then that would impact, so much in software and everything that we're doing as far as technology goes. So that seems to be the case. So I was taking some notes during the discussion. So, the term authorized. So that takes care of that. So what does authorized mean? And authorized seems to mean what I thought it meant when I was reading that term authorized. And then other people in the comments said as well, like, what does it mean to be an authorized license? That word was put in there because I said, well, how do you know if you got an authorized license? Well, you can't publish it off of like a draft or a leak or something that's not intended to be released publicly. And Dancey was saying that, yeah, we put that word specifically in there. You can release this under an authorized copy of the license because different drafts of the license were circulating when they were drafting this, passing it around from person to person, different publishers as well. Like, here's what we're looking at. What do you think? and passing it back and forth for commentary, that those drafts being passed around are not authorized copies of the licenses because they're just drafts. So that word is there specifically to say that once it's published, put out in official capacity on that date. He said that it was actually released on the first day of Gen Con of that year. That's when that becomes an authorized version of the license. And there is no mechanism for deauthorization that becomes an authorized version of the license. And I was checking this whole situation, like, what does this go off of? Like with the GPLs, the general public license, which I'm not in the software area, but while I was doing all these notes and before the stream, I was reading through GPL version 1, version 2, and version 3. And it was even talking about how you publish under each one, when there's a new license that comes out, or that you can still use older licenses, and that's all covered in there, right? So following that precedent, right, you're going to have this authorized version of the license. It doesn't preclude someone from producing a new license, correct? But very much like the FAQ said that, well, you can't deauthorize the first one. If you're going to do something with a new license, it's got to offer something new to publishers who want that new thing that they didn't get with version 1.0A, right? And so they would change. So that idea of authorization. So that to me personally, that resolves any doubt I had regarding authorization and anything about revocability or something like that. To me. Let's see. What other things did I say? Okay, so we did say, and he said that the revocability is inherent. The irrevocability of it is inherent because nobody would use the OGL if it were revocable, because they wouldn't want exactly this thing to happen. And so the only reason that you would ever use the license is if it were irrevocable, that was not something that's in there. Mark says, most definitely. Glad that was confirmed and clarified. There were draft, and the use of authorized was put in there to mean the final 1.0A wording was the final word, right? And then it's put out through some kind of an official channel, and then, yes, you have yourself an authorized version of the license. Okay, so Judy is also talking about coming from now a Canadian lawyer too. So this is also important because we talked about, and that discussion generally had to do with the context of U.S. law. But as people have been pointing out, okay, Canadian law is another thing, and then how things are going in the European Union, how this could possibly be addressed in the European Union is something else entirely. Yes, thank you. Please do hit the like button. Let's see. Now, I have no authority in this at all. I have no authority, no insider knowledge or any kind of authority. But in my opinion, after trying to run all this down and the comments and everything like that, it seems like you cannot do away with 1.0A. That's just not within the powers. They did a fantastic thing. So Ryan Dancey, and you really appreciate that when you listen to that stream. He made sure that it was battle tested and bulletproof, that something like what was potentially about to be tried as the result of this leak cannot happen. So that is my understanding. So I feel good about all of my friends' stuff. Now, I guess our next big thing then will be what Wizards actually releases. I guess that'll be the next big thing to talk about, because to me, the ambiguity that had all of a sudden popped up for a few days seems to have been clarified. Vision says, seems like a Wizards of the Coast lawyer was looking over that authorized and seemed like they didn't know what they meant when they said authorized. It could be, but that's a whole lot to be looking over, and all of a sudden basing all of that 1.1 nonsense on that. I mean, that was a lot to not understand if that were the case. So the idea that also within the software that the irrevocability of it is inherent, and basing all of these things with the open license. And this doctoral dissertation talks about that as well. Talks about that being inherent in the idea of open licenses. So it's not something that you have to put in there because it's inherent. That was basically what we got there. I thought that was important. So he also addressed the question, because we had looked at on one stream, we had looked at the Creative Commons license, right? because we said, for instance, fate. Now, because you can use, okay, let's actually start here. He said, okay, somebody asked if you've got the 1.0a and for some reason it did go away. For some reason, we don't think it can, but if it did for some reason, can somebody else just republish the 1.0a like the Open Game Foundation, which he had set up and is a website there that holds some documentation about a little bit of documentation. Basically, he was calling it putting a flag down to put some type of stake down to point to this is when all this is going on. Could somebody else publish the 1.0a and then have that license? And the answer seems to be yes, because then you can just use that license or something very similar to it. But the value of that license comes not in the fact of its inherent value as a good or bad license, but it comes because it's specifically giving you access to the D&D mechanics, right? And that's what makes that so valuable. So yes, other people do create open licenses. I believe that the Cypher uses a different one. We're going to look at Cypher RPG on the Morning Grind one day soon. They have a different license. We were saying that Fate, or Evil Hat with Fate, you can license Fate under the Open Gaming license because they've just put Fate, the core rule books, under the Open Gaming content. So you can use the Open Gaming license, or you can license it using the Creative Commons licenses. And many of us seemed to like that as we were on the live stream, as we were looking at that and kind of reading through what the Creative Commons license was. Now, there are many different versions, which is actually the issue here. So there's a specific Creative Commons license that Fate is licensed under and seemed pretty good to us. You can use it. You can use it for more stuff, but you just have to give credit and say that this is where this material comes from when you're using it in your own work, and it gives you that verbiage there to put for that credit in there. It seemed like a great license, but Dancey specifically addressed why they did not use the Creative Commons licenses, which doesn't mean that it's not a good idea for you. If you're writing a game or something like that and you want to put on the Creative Commons license, because I would definitely think about that, especially as we were looking at the other day, could use the Creative Commons license, or you could use the OGL. But he says that they looked at the Creative Commons licenses, and the Creative Commons has a variety of different licenses, which I did know that. There are a variety of different Creative Commons licenses. Some of them that require your material that you make off of the work to also be basically open commons material. Other ones that it does not. For instance, like the Fate thing, the Fate license is the one where you can use it, you can remix it, even commercially. You do have to give credit, and then what you create off of it does not also have to become open under the same license. And so that allows you to do something like create the Dresden RPG. Because, okay, Dresden and stuff, you can't make open and whatever else, and you create custom stuff for it. And so you can just end right there and use all the material. And somebody else can go back up to the original file. But Dancey said that the reason he didn't want to use Creative Commons is because it was too fragmented. He said there were fantastic he said that as far as the drafting and the language of the Creative Commons stuff goes, all of that is fantastic. They're great licenses. But the issue is there are lots of Creative Commons licenses, some of them that are extremely open and extremely permissive, and then other ones that are not and that are extremely tight and rigid. And so when you just say, hey, this is available on the Creative Commons license, nobody knows exactly what Creative Commons license that is. And there's a whole variety of them. And is this like, the SAU, whatever, they've all got the Creative Commons CC dash and then a whole bunch of letters. He said that was too complicated. It was too fragmented. He didn't want that. He wanted something people would be very easy to understand. And so, boom, open gaming license. That's what that is. And it's, that one-page document that does exactly what it's supposed to do. So I thought that was a great explanation because it answers one of the questions that we had on the stream as well. Why not just use Creative Commons? Maybe that is a great alternative. So I thought that was great. So what did we talk about? We talked about that. We talked about inherent revocability. We talked about authorization. We talked about, and that Hesbro being there. So there's one other thing that came up that I thought was fascinating that has to do with trademark, which is a weird thing. I'll check the chat. A weird thing regarding trademark law that you would be able to do, except for the OGL forbids it. And the dissertation talked about this as well. So let's see here. Well, we'll see. I mean, Dancey seemed to say that we shouldn't be worried about that. In his opinion, this is just his opinion, but it seemed to be that in his opinion, this would be an easy thing for the court to solve because it's only based on, does Wizards have the right to deauthorize or Hasbro have the right to deauthorize 1.0A? And to him, it seems extremely clear cut that is no. Well, we've talked about that as well, Judy says, because there are different levels to this. There's having to get through litigation, and then whether or not you're right, whether you can get through litigation and all of that financially, and then does the court end up agreeing with you? But if it's this clear cut, I mean, as it seemed after that, yeah. Axiomatic to the existence of the license itself is the language Ryan used. This is Mark Hyde here. Ryan used the OGL 1.A revocability. Right. Yes. He was he's like was the vice president. I forget exactly the title that he said, but it was like vice president at Wizards of the Coast at the time that was like responsible for managing the D&D brand. And so they came up with this idea and he managed it. Yes. And Ryan said he worked with the in-house counsel at Wizards of the Coast, Brian Lewis, to co-author it. He was the one who came up with the legalese. Yes. Thank you for that clarification. The presence of the shield is distracting. Is that not a good place for the shield? But cool set. Thank you. I appreciate it. I designed this whole thing for streaming in the whole house for what we're doing. That's exact vision. That's exactly where I was going to go. So I'll go do a few more comments. But the compatibility, that was a extremely interesting part of this. Yes, it was. So let's see here. Let's see if there's anything else that's that we should bring up here. Yeah, unacceptable naughty professor did watch the Roll for Combat, found it very interesting. Okay, so yeah, I believe it was Vision that brought up the next thing that I was like, oh, this is freaking fascinating, which has to do with trademarks. We might have to, I might bring up the text of the OGL here, but okay, so ordinarily, okay, and he was saying that trademark law is much more clear cut in what is allowed and what's not allowed than generally copyright is. It can be gray areas and things like that. But he seemed to say that there was a lot less gray area in the area of trademarks. But one of the fascinating things about trademarks is that you are perfectly free to say that your work is compatible with some kind of trademark. That according to trademark law in general, and there's going to be an exception here with the OGL, but according to trademark law, if you make something that is completely compatible with, I don't know, the Apple TV, okay? The Apple TV, he says that according to trademark law, you can definitely advertise your product as being compatible with the Apple TV. Now, he was saying it does actually have to be compatible because otherwise there's something to do with there. But if you actually are compatible, then you can say that you are compatible even with something trademarked. That would mean, and there was also so much more in there about the trademark of mechanics or excuse me, copyright to mechanics and stuff like that. But this was interesting. So there's actually nothing, according to raw trademark, that said if you created a game that's compatible with Dungeons and Dragons, you could put on there compatible with Dungeons and Dragons, that you could use that trademark, you know, to say, not use it, but put on there the trademark on there. I guess you're using it in a certain sense, but you see what I'm saying? To say this game book is compatible with Dungeons and Dragons. That would be allowed. Okay, now why don't we do that? Because obviously we don't. Here's the Ruins of Symbaroum, and it's got this 5e. Now there's no standardized 5e. That's one of the issues here. So we got 5e up here, and then a lot of people will use different symbols. That one's kind of basic. Where'd this one go here? I mean, I guess everybody knows what we're talking about. But for instance, here's Lou's Thrones and Bones, and we've got 5e right there. And of course, a lot of different people, you know, put 5e on there. There's no standardized logo for that. But we in the gaming community have just kind of adopted the idea that, well, 5e, if something says that it's 5e compatible, then that means it's based on the SR, the 5th edition SRD open game content license, and you can use it. It's compatible with your Dungeons and Dragons games. Okay, now why don't we do that? It's because why do we do that instead of just saying compatible with Dungeons and Dragons and putting Dungeons and Dragons on there? It's because the OGL specifically prohibits you from doing that. If you publish under the OGL, because there's the section about, what is open game content, and then what is product identity and all of that. And then also in there, it specifically tells you that you can't use the Dungeons and Dragons logo and trademark and stuff. So according to what he was saying, which I think is fascinating, ordinarily you'd be able to write something and say, this is compatible with Dungeons and Dragons, if it is. But if you're publishing under the OGL, they prevent you from doing that. And so ironically, if something happened to 1.0a, theoretically, you could just start saying your products are compatible with Dungeons and Dragons, right? And then you'd actually be able to put Dungeons and Dragons on your books. Because, that's what, if the concern here is that with the mass marketing of the movie and the TV show that's coming out, the general public associates role-playing with Dungeons and Dragons, and they just want to go and get something that is Dungeons and Dragons branded, then what they should do, what they will do is go and buy, this box right here. Boom. Because that says Dungeons and Dragons. They will not go and pick up, for instance, Lou's book, because that does not say Dungeons and Dragons to somebody who is new. Someone who's just coming in because they just saw the movie. They stopped by Target or whatever and want to pick up something Dungeons and Dragons related. But if that changed, so that the open game license is actually protecting Wizards from that situation. It's keeping Dungeons and Dragons off of our books if we're publishing under the OGL. I thought that was fascinating. So actually, this, that's helping Wizards. Why would they get rid of that? It seemed like from listening to that, I really could come up with no reason why they would want to deauthorize it, given all this stuff that was talked about. It seems like it's working for them in many regards. In many regards. It's like all hurt. Like it's all pain if they tried to do it. For them. It's all pain for us, and it's all pain for them if they tried. So why even try? I thought that was fascinating. Let's see here. Hey, Renee. Good to see you. John says, coming in from Twitch, by the way, welcome and good to see you. Good to see Twitch people here. John says, I've often wondered about that compatibility issue since Windows 95. Scott says, Witches of the Coast is already out here acting like they aren't system agnostic VTTs like Tabletop Simulator, and their entire library isn't available as PDFs on any flip. Let's see. Okay. So where do we go from there? I think those were the key points of the discussion as far as I was concerned that talk directly to the issues that we've been talking about on the stream. So let's go over here because I've got some highlighting over here in this dissertation. Prior to that discussion, this dissertation seemed to have just a tremendous amount of information. It does have a tremendous amount of information on it. And I'm sure, has anybody been interviewing the creator of this dissertation? Let me bring this up on screen. There we go. So, and it wasn't even written that long ago. And, this is 2019. This dissertation was written in 2019. And it says, if you love something, or the title of it is, if you love something, set it free. Open content copyright licensing and the creative cultural explosion. So there's a lot in this dissertation about, as far as the research went, about the effect that open content and open licensing, how that works and how that contributes to creative expression, which, yeah, isn't quite as relevant to what we are doing here. But I would say that when I went through it, and I didn't go through it in complete detail, but I was looking for certain key things, especially as like what is most relevant to the questions that I have and we've had on the stream. And I wanted to know, first of all, especially since this is 2019, not all that long ago, the dog not barking, that elephant in the room, right? Why is nobody saying that, hey, there's this flaw, either intentional or designed in the OGL? Well, this guy did a whole PhD on the subject in IP law, and nowhere in here that I could find, because it's not in here, does he say, oh my God, there is a critical problem with the OGL. That, oh, look, because he's dissected it at this level, and nowhere does he go, oh, there's a problem with it. In fact, to the contrary. So this is the abstract and what he was actually trying to do here. But I'm going to get us just into what's relevant here. But here's the abstract of the dissertation. This dissertation seeks to answer the question of whether open content copyright licenses can be most productively used to facilitate the creation and dissemination of cultural expression. So the dissertation itself isn't on like the quality or the open gaming license as a research topic, but it's a whole chapter in here. This dissertation posits that copywriting, this dissertation posits that copyright licensing is best understood not as a mechanism for maximizing monetary returns, but instead as a mechanism for increasing creative participation and communication among community members, which is definitely what the open gaming license has done with Dungeons and Dragons and tabletop gaming in general. At the heart of this research project is a case study of the use of the open gaming license, the OGL, in connection with the Dungeons and Dragons role-playing game, and how that licensing model has resulted in a vibrant community that creates, remixes, and shares open content. Open content copyright licenses can be most productively used when licensors are committed to nurturing and facilitating a community of creatively engaged consumers. Most notably, that is not what Wizards of the Coast has been doing since last Thursday night or something, right? Yeah, we used to have someone who's committed to nurturing and facilitating a community of creatively engaged consumers, but don't quite feel that way anymore at the moment. Yes. So this is the author here. Yes. Now he has been interviewed on YouTube, and that could be it. And Roll for Combat also played that video where he was talking to. He was on another YouTube channel that was specifically dedicated to contract law, and so that was that context. But somebody's got to find him and talk to him. I'd love to talk to him. Maybe it's time to have another table talk show where we interview somebody. Would love to do that. Judy says, it sounds like the OGL has been working quite well for some time, but it's under-monetized. Arguably, but arguably not. Like with the value of Dungeons and Dragons, I mean, it's an interesting argument to make because, as Dancey was saying, like when he took over Dungeons and Dragons, it was in terrible disarray financially. And then, then the OGL happened. We had this explosion. And what is Dungeons and Dragons worth today? Incredible amounts. And it's probably because, no small part because of this. But some people at Wizards or Hasbro may think that this is some kind of obstacle they've got to get rid of. Mark says those points are exactly highlighted when Ryan was saying on Roll for Combat stream as to why the OGL was created. It is exactly. Yes. Okay. So let's look at, we like to look at table of contents here when we're looking at stuff. So this shows you what's in it, but we don't need to go through all these different chapters, but this is what's in it here. So the introduction here, I did try to go through it and find certain words because I was looking for words like revocability or irrevocability or authorize or perpetual, dealing with the issues we're most directly concerned with here. And I did highlight them when those words came up as we're scrolling through here. But, okay, so like chapter 1 is copyright licensing and copyright justification theories. So that's a literature review of all of that. I don't think necessarily relevant to what we are doing here. So chapter 2 is communicative copyright as cultural conversation. So that's chapter 2 here. Chapter 3 is defining the open game license. So here we go in here, and he does break the open gaming license down. So this is starting on page 66 for chapter 3. We might start there looking at stuff. So introduction, definitions developed by advocates of open content. What is the definitions? And we find out in here, and he talks more about that the irrevocability of it is inherent. Scholarly definitions of open content licensing. An operational definition of open content licenses. Content and development. The community, and then next, chapter 4, the commutative constructive function of indicia of success. So that's part of what he does here as part of his research, is determine how do you know if your open license is being successful. Actually, this might, I don't think we need to go through that on this stream, but that might be answering some of the questions here when we're talking about has it been successful? You know, is it under monetized? Is Dungeons and Dragons under monetized, or is Dungeons and Dragons only, or in large part, valued at what it is because of what has happened with the OGL? Maybe as a result of his research, he might have, that might be what that's doing here, coming up with some type of way that we could actually make some type of judgment call about that. Fieldwork methodology, he talked to a whole bunch of different people who are using the OGLs. That was that. But then chapter 6, I think, is important to take a look at. And it's rather short. So I think chapter 6 is particularly relevant here. The history and mechanics of the open game license. Introduction, the background, the road to the open gaming license. And a lot of this was probably talked about in that stream. So it's interesting to hear it from the academic perspective and then also from the person who was in the room actually making it happen. So the impact of the OGL, consequences, mechanics. Was the OGL needed at all? This chapter is one that we need to look at. And then chapter 7, field work, successful use of open licenses for creative expression. So that's what's in there. So I'm going to scroll through here because I've got, if I find something that is highlighted that I went through, then we're going to call that out. But otherwise, I think looking at chapter 6 is the one that's the big thing that we need to take a look at. Let me look at chat for just a moment. Yeah, see, lots going on here. Yeah, we know that Hasbro paid Hasbro. So I didn't know this number, but we do know that Hasbro paid $350 million for Wizards of the Coast. They paid and then Wizards of the Coast paid like $140 million for D&D Beyond or something like that, $145 million or something like that. Oh, hey, Piano! I am so glad you're here. I'm so glad you're here. Piano has been putting lots of material in the comments here in the chat, but also in comments on different YouTube videos, specifically about this issue of irrevocability and perpetuality. So I wasn't going to be here. I had a 5e session, but the GM worked late and he's exhausted. So I have time for this. Well, welcome, welcome, welcome. Now, we did discuss this. That's where WotC fails. They barely support their own, supplement their own product. They should most certainly just ignore the third parties and do some casual actual work and produce these supplements. Well, I thought that Ryan Dancey's thoughts on this was interesting because okay, all of a sudden Wall Street has noticed that Dungeons and Dragons makes a lot of money, okay, and that it could be making more. And so what do people on Wall Street want? They want Dungeons and Dragons to make even more money, right? They want Dungeons and Dragons to make even more money. So how would Wizards of the Coast do that? What would a Wizards of the Coast strategy to do that be? Well, could it be to publish more Dungeons and Dragons books? Arguably, in Jeremiah's case here, and other people would say as well, that they should publish more books, that we would like having more Dungeons and Dragons books. But on the other hand, how many more Dungeons and Dragons books can we buy? Especially, you know, there's an increase that we could probably do. They could probably produce more, but is that actually going to generate the level of revenue that Wall Street wants? Or he talked about, well, we could do novels. Like, could there be a Harry Potter level novel that we're about to publish about Dungeons and Dragons that's going to just, you know, blow the socks down, blow the roof off of Dungeons and Dragons in that way? You know, they are looking bigger. Like that's why I see things like the movie and the TV show. What are big things that can drive more eyeballs and get more things on it in a big way, more than just selling us more books? He was saying, I think it has to do with the movies and the TV show, getting the Dungeons and Dragons brand out even further into the world. And then Ryan Dancey was saying he thought that the strategy to monetize that was really the digital tabletop space, and locking that down, trying to lock that down, and becoming the de facto place, and maybe the only place that you can go for online tabletop gaming. That we're moving away from books and rolling dice. It's just going to be an all digital thing. Get the brand out there from the TVs and the movies, and then capture everybody and monetize them through this massive online platform, which, as he pointed out, they paid $145 million. If you shell out $145 million for something, you want to return in a big way. So that might not be in order to selling more books. Let's see. Is D&D still a hobby franchise? Well, it is a hobby franchise, but it's trying to become more. And like it's trying to become, they want it to become a brand like Star Wars. I mean, I think that, you know, the D&D brand, they'd like to be Star Wars or Marvel. Nash, good to see you here. Glad you were able to make it too. Okay, let's go through here. I'm going to go back over here to scroll here to see if I hit a highlight. Oh, I did hit a highlight here. So, okay, this is one. See, this is one of my. See, it's not really useful here, but Newman, we can put here. The word revoke was here, which is why I flagged it. So this is in the context of just saying, for the sake of completeness, the core concept of the heart of property are those of ownership and title. By ownership is meant an indefensible or irrevocable interest, the absence of a superior right to claim the rights to control the resource, which is subject to the property right. And then he uses the footnote here to reference somebody else and says, an ownership interest is one that nobody possesses any power to revoke. So that's when the word revoke is used here, one of the contexts. Not specifically related to the OGL in the OGL analysis. Let's see here. I'm glad the leak of 1.1 wasn't 300 pages like this. I guess we should count our small blessings. That was only 15 pages and not 300 pages to try to go through. Let's see. Wait, what is this? Defining, chapter 3. Oh, yeah, we did want to see. Okay, let's look in here. Defining open content license. Okay, broadly speaking, in plain English, an open license is one that grants permission to access, reuse, and redistribute a work with few or no restrictions. In plain English, not necessarily legal language. So, distinguishing open content from other open initiatives. We need some bullet points. So this, we do reference the GNU here, which all of this is kind of based on. The philosophy, which is actually older than I thought it was. The first GPL was out, I believe, in the 80s. Scrolling down. We need stuff on, I'm looking to hit one of my highlights. This is publicly available. So if you want to get into this in more detail, you can download the dissertation yourself and curl up with a cup of coffee. Okay, so here we go. So this right here, necessary features. So necessary features of open content. So I think this is where I hit a word that I was like, okay, wait, this is cluing me in, because a perpetual is used here. So let's go necessary features. So this is necessary features of open content. The operational definition identifies as necessary features those aspects that must be present in the legal relationship between two or more parties in respect of a particular jural object, and in order for that relationship to be considered an open content license. Okay, so I think we're going to give some ideas, some examples here. As a threshold matter, the relationship between the parties, the punitive licensor and licensee, in respect to the jural object in question, must be a license. Further, the jural object being licensed must be a work or other subject matter protected by copyright. Okay, so that's important. So it could be something protected by copyright. In order to be dealing with this, the jural object, that's your license. We're trying to decide whether or not this jural object is an open content, or it's an open content thing, right? I believe that's what we're doing here. So it must be expressed in the form of a license. What it's licensing, the jural object being licensed, must be a work or other, excuse me, the jural object being licensed must be a work or other subject matter protected by content. That would be like the SRD. My understanding of that's the SRD. The license must be non-exclusive and available for take-up by any interested party who wishes to observe the conditions of the license. Okay? And then additionally, the license must have a stable form, i.e., there must be a given point in time be a version of the license which is capable of being accessed by the licensee and identified as the definitive authoritative version of the license. I think that sentence is very important because that's exactly what speaks to our idea of authorized. What does it mean to have an authorized version of the license? This dissertation is saying that is actually an essential part. Authorizing the license is an essential part of being open content anyway. It's an essential part of it. The license must have a stable form, not the drafts being circulated. There must be a stable form of it that can be pointed to at a single point in time, which is also what that Open Gaming Foundation website does. Gives you a point in time. Here is your stable form. This is now authorized. The licensee can identify it as the authorized version of the license, and now you can publish under it. That's what that means, as my understanding goes. I come out of academia, but I'm not an IP lawyer. But when I heard somebody else's dissertation was up, I had to get a chance to get into somebody else's dissertation, right? Which typically you don't want to do. Most dissertations never get read. So this one all of a sudden became insanely popular, unless for some reason something happens and all of a sudden you become insanely popular. So this, I wonder where this will rank on list of most read dissertations. The grant of permission. Okay, so now here's the word perpetual. The grant of permission contained in the license must be perpetual, i.e., at least equal to the longest potential term of copyright protected under any copyright regime, and irrevocable by the licensor, subject only to revocation for breach of the conditions imposed on the grant of the license. That's our next most extremely important sentence right there. I'm going to read that again because this goes directly to us. This is when I was talking about perpetual. We had that in the comments here, and I said there was something to do with copyright as well. I think this is an interesting kind of caveat to that because we have to we have to be licensing our jural object here must be something that is protected by copyright or maybe possibly protected by copyright. That's like the expression of our rules in the SRD. So in order to be something that is open, the grant of permission contained in the license must be perpetual. So what's our meaning of the word perpetual? Because perpetual is in our license. At least equal, meaning at least, or i.e., at least equal to the longest potential term of copyright protected under any copyright regime, and irrevocable by the licensor, subject only to revocation for breach of the conditions imposed on the grant of the license. Boom, right there. Right there. So that's interesting that eventually the SRD, the 5th edition SRD, would have its copyright expire. Like eventually at some point it would become public domain. And so I think it's an interesting caveat and just note here that we're talking about something that would be under copyright. Once it expires and copyright expires and it goes into the public domain, I guess you don't need an open license anymore, right? I guess that's what that's saying. But we are definitely within the time frame where something like the SRD would be protected by copyright, and that's why we have this. And it's irrevocable by the licensor. Piano TM has been talking about this. So that tells you in the OGL exactly this, right? It is irrevocable by the license. It does talk about termination. Now, do we need to track down the difference between revocability, revoking something, and terminating it? I don't think so, because it tells you right there, this is talking about the exact same thing. When it's talking about termination, it's saying that if you breach the licenses, if you breach the terms of this license, then then it's terminated, right? If you're breaching the terms of the license, then you don't get to use it anymore. So irrevocability can only occur if you breach the license. I mean, to me, that's big. That's huge right there. Getting them onto the virtual, it says, it seems their goal is to get everyone on the VTT when they can charge 5 cents for every attack you make. In order to do that, they have to plow the existing field before they can plant a new crop. Yeah, that is hypothesized to be the potential monetization strategy after doing perhaps something like the movie and the TV shows. Piano says, YouTube's heavily moderating my OGL comments. I don't know if it's because they present similar information or if something else is going on. I have not been able to catch up on all the different comments, but I did notice as I was scrolling by that you said something about some kind of, you thought that I'm not doing any type of moderation of comments like that, certainly. So if there's something that comments are not showing up or something like that, it could be on YouTube side. And that's kind of strange. I have no idea what's going on there. Let's see. Barbsy says, can we make physical tabletops with digital tile components that connect over Wi-Fi and we play together from home? Well, I think that's fine. I mean, I think that, it sounds like they're trying to claim, like with 1.1, and other commenters have mentioned this, more than they can actually have the right over. Andrew is talking about the stock price, and yeah, the stock price has been going down. It hasn't been helped by this. Jeremiah says the problem D&D is vast but vague. I use Warhammer as an example because they have gone every single route to produce vast content in their digital space. BG3 is a good example of a heavy lifting. Well, and they produce just tons of physical product as well to support Warhammer. Now, they canceled Warhammer Fantasy Battles, which I played, but Andrew says, full Hasbro statement is on their website. I can post a link, but unsure if allowed here in chat. Some people are saying that they cannot. When did Hasbro put out a statement? If you've got one, hey, put that in Discord, because some people say that it doesn't allow you to post links in chat. I'm here in Discord, though. Somebody's in Discord. I'm going to, where do I need to be? Under D&D. There's so much going on in the D&D space. Okay, I'll be in the D&D tabletop, the D&D channel under tabletop games. So if Hasbro has put out something, then let's look at it. Send out a link. We'll look at it together. In fact, should I just... This is not 300 pages. Oh, no, excuse me. This is 300 pages. Their statement is not 300 pages. At least I hope. Let me just go to the website and just see what I see. This is a dissertation, so 300 pages is not... it's pretty standard. I don't see it just on the main page. I wouldn't expect that anyway. If it'd be on the main page, I have to find it. If you've got a link, put it in the Discord server. We will check it out. We'll be fascinated. We really need to see that. I have no idea. Marcel asks a good question. What would happen if I release all of my materials under GPL 2.0 for my fan-made material? I have no idea because I'm not any kind of expert on GPL. And like if you're making software content, it might be perfect. I don't know because I mean, isn't it primarily used for software? Maybe there's some kind of adaptation for other written materials. That's an interesting question, and I do not know the answer to that. Oh, referring to Hasbro's earning report. Okay, yes. Okay, so Hasbro's earning report is probably on its website. Got you. There might have been a false alarm. Sorry about that. But yeah, the earning report would be public. So, see, Darth Gavel says, that's the smoking gun. But then Piano TM says, perpetual loan isn't the smoking gun, it's the hammer. The trigger is the revocation, cancellation, or termination clause. Those work together to make the OGL irrevocable. And Piano has been our strongest supporter and advocate of exactly that position. And so I think I'm in agreement. I'm in complete agreement. Wizards of the Tower says the term of copyright for a particular work depends on several factors, including whether or not it's been published, and if so, in the date of first publication. Right. So, and it also says, you know, in all regimes, and I'm assuming that's something like all jurisdictions, you know, so that, well, it's out of copyright over here, but it's still under copyright over there. So the license still applies. If you're in an area where the copyright could still apply, then you can still access it, the material, through the open game or an open license. So the permissions accorded to the licensee pursuant to the license must not expire with the use by the first licensee or upon a certain number of uses by a certain number of licensees. You can't restrict it by number then. The core feature of an open content license is the set of permissions granted by the licensor to the licensee. This definition adopts the entirety of Wiley's 5 R's in describing the set of activities which must be permitted in respect to the licensed work or any part thereof. Wiley's, I guess this is 5 R's of open content. These activities must be permitted. Retain the right to make, own, and control copies of the content, meaning download, duplicate, store, and manage. Reuse the right to use the content in a wide variety of ways, in a class, in a study group, on a website, in a video. Video is an interesting one. Oh, there was information on streaming. We'll talk about that. Video is an interesting one, particularly with regard to the OGL. Revise the right to adapt, adjust, modify, or alter the content itself. Translate them into other languages. Remix the right to combine the original or revised content with other material to create something new. Redistribute the right to share copies of the original content, your revisions, or your remixes with others. Boom. So those are our 5 R's, which it seems like the OGL, we intended for these things to be there, and they are there. That's what that is. In addition, the license must permit uncompensated exercise of the 5 R's. Finally, depending on the jurisdiction in which the license must be assessed, the license must contain either a waiver of the owner's moral rights, or 2, a covenant by the licensor not to assert, enforce, or otherwise exercise his or her moral rights in a manner which would interfere with the uses otherwise permitted by the license. So this is the license must contain the waiver by the licensor of these things. So that what we were just going through there were necessary features. In order to be an open license, if something is an open license, these things are there necessarily. These are indicative features, which probably are not as necessary to go over, but it says indicative features are those that are often but not always present in open content licenses. Their mere presence does not render a content license into an open content license unless they are accompanied by the necessary features. The first indicative feature of an open content license is the presence of a connection between the license and a public statement by the author or sponsoring issuer of the license of principles or aims to be furthered or achieved through the use of the license. Oh, well, that is interesting. I'm going to highlight that. So we do have that. Maybe this is important to go through because we do have that. Wait, hold on. There we go. They definitely did this. They publicized that. They talked about their intent. Ryan was talking about that, and that how he had a gentleman's agreement with other publishers. Because I didn't know there were also books that were available under the open gaming license the very day that the open gaming license was authorized. And he said he did that by having publishers, basically a gentleman's agreement with publishers that said, yes, this is what we're doing, is real. If you print up all these books, right, which is a huge cost, if you make the books and then print them all up, they'll be ready to sell on Gen Con, and I'm going to give you my gentleman's agreement that, yes, this license is going to enforce, and they will be there, and you will be able to sell them at Gen Con as soon as this goes live. In the absence of a formal manifesto, there may be other observable connections between the license and a relatively stable defined political or social movement or initiative that cites openness, access, or freedom as its guiding ethic. The second indicative feature of an open content license is the presence of copyleft, viral, or share-alike provisions. Not necessary, but indicative. It's widely recognized in the open source community, however, for example, that share-alike provisions are often present in open source software licenses but are not required for qualification as an open license, which is important also with us in the open gaming community, that you can use something, but you don't necessarily have to make stuff that you make off of that also open. You can using the open gaming license, but you don't have to. Non-disqualifying features. Let's look at that's short. Something might be relevant. Non-disqualifying features, consistent with the approach adopted by the DFCW and the open definition. This definition includes non-disqualifying features, which are those whose presence does not prevent a particular content license from qualifying as an open content license. So this could be important because, oh, look, it has this. It's not an open content. No, not really. It can have it, and it does not disqualify it. While the presence of these features does not prevent a content license from being considered an open content license, their presence can impact the analysis of the openness of an open content license as compared to open content licenses that do not include these features. Attribution requirements, or requirements that the licensed work be accompanied by a copyright notice, do not offend the operational principle or do so only minimally, and so do not disqualify by virtue of their presence. I'm going to highlight that. Oh, there. Similarly, requirements that a copy of the license be made available in conjunction with the licensed work impose only a negligible burden on the licensee, as do requirements that any modification to the licensed work be identifiable by a statement that modifications have been made to the original version of the work. In the same vein, an open content license can require licensees to provide notice of use to the licensor, provided that such requirements are relatively easy to comply with and do not impose unreasonable or undue burdens on the license. So we do have that in the OGL because that's why everybody's got that page in the back of their book. And there is no requirement to provide a book, but sometimes you do see that. If you publish something with this, I would like to see a copy. Now, sometimes it's not a requirement. It's just something they would like to see. As discussed above in the context of necessary features, there is no prohibition on the licensor imposing a cost in connection with the grant of the license or the sale of the licensed work which is made available under the licensed. There's no prohibition on the licensor imposing a cost in connection with the grant of the license or on the sale of the licensed work which is made available under the license. The licensed work need not be free, meaning the grantor can charge a fee for initial granting of the license, but the grantor cannot impose a royalty triggered by exercise of the granted rights. Well, that's interesting. So you could give somebody an open license and you could say, hey, it costs $10 in the beginning, and that would be okay. That would be this is a non-disqualifying feature. That sounds I don't see that a lot. Maybe it's in software and stuff like that, but I don't see that a lot in tabletop. But we know here. But the grantor cannot impose a royalty triggered by exercise of the granted rights. So that would be something that's incompatible with open content. The lack of prohibition on imposing a cost stems from the fact, so this is why, so this is interesting. The lack of prohibition on imposing a cost stems from the fact that the operational principle is considered with activities relating to the use of the licensed work after initial access. So wait, the operational principle is concerned with activities relating to the use of the licensed work after initial access, rather than in the initial making available of the licensed work. Relatedly, because the operational principle, and that's the operational principle of open content as I understand it, is oriented towards use maximization, prohibitions on licensees imposing digital locks or other technological methods that restrict access to the licensed work are permissible. An open content license can also contain restrictions on the licensee's use of other intellectual property rights owned or controlled by the licensor. And so we also see that. That's the restriction on you can't use the D&D trademark itself, right? Such restrictions are permissible because the operational principle is concerned with maximizing the use of copyright protected work, and restrictions related to the use of the licensor's other IP rights do not impose restrictions on the licensed work. And that's important for many of the stuff that we're doing. Like I'm working on world building on the channel. I love world building. So need rule sets, working on rule sets or adopting a rule set. Right. Those are two different things. So the IP that's coming in and then the licensed work, for the open licensed work for the rule set. Let's go over here. Let's go to the... So GCW 1978 says, okay, so I'm not, so I'm the most layman of laymen, but should we not bear in mind a dissertation, legal opinion, not case law? Oh, absolutely, absolutely, absolutely. This is not any type of case law. This is somebody who wrote their doctoral dissertation in IP law, specifically with regard to the OGL. Yes, that is absolutely the case. Lots of stuff on the stock and earnings, I see. Yeah, Blue Jay, the OGL 1.0 and 1.0 never gave the power to deauthorize or revoke it. And Ryan was saying if we intended for that to be preserved, we would have explicitly reserved it. Oh, we got, spam bot, time to breathe and drink. We had the spam bot. They can update it, yes. And we can choose whether or not to use an updated license or not. Okay, so let's go back over to where we are right here. So disqualifying features, that's probably important. Disqualifying features. Consistent with the approach adopted by the DFCW, I'm not sure what that is, we have to look that up, and to a lesser extent the open definition, and an effort to maximize definitional certainty, this definition includes disqualifying features, but I would say that, yes, keeping in mind this is not case law, this is doctoral dissertation, it's extremely helpful with regard to understanding for me it has been anyway, the definitions of these things and what's actually being talked about and the legal definitions behind the philosophy of open content. So, and in an effort to maximize definitional certainty, this definition includes disqualifying features. That is a feature whose presence prevents a content license from being considered an open content license. Whether some of these restrictions, such as use-based restrictions, can be included in open licenses is a hotly debated topic within various open licensing communities. For example, whether only non-commercial uses can be made of the licensed content was the precipitating disagreement for the split between free software and open source communities. In creating this definition, I am seeking to respect the principle of use maximization at the heart of the open content ordering principle. Elected to stipulate that restrictions that are use-based or based on the identity of the licensee are impermissible restrictions because A, they seek to preemptively limit the pool of potential licensees, and it has to be open to everyone. B, they fail to respect the principle of use maximization, and C, they are inconsistent with the principle of fairness because they introduce definitional uncertainty into the process. Whoa, and as we are finding out, definitional uncertainty can be a huge thing, right? We certainly wouldn't want to introduce any more definitional uncertainty than we already have here. For example, forcing licensees to conduct potentially irresolvable inquiries into whether or not their desired use for a licensed content is commercial or non-commercial or constitutes the creation of a derivative work. Thereby compromising, this does give us specific information on whether or not 1.1 is an open content license, right? Like we could go through exactly what's in 1.1 that we went through and figure out whether or not that's actually an open license or not, or are they just trying to tell you it's an open license? Because it didn't sound very open to me when I went through it. Okay, thereby compromising the embedded principles of predictability and flatness of availability. The inevitability has boundary drawing consequences that may not accord with the conclusions reached by others. For example, using this definition, a Creative Commons license bearing the NC non-commercial or ND no derivative works modules would not qualify as an open content license. Would not qualify. A Creative Commons license bearing the NC non-commercial and no derivative works modules would not qualify as open license content, whereas a Creative Commons organization concludes that such a license is only less open. Okay, whereas they say it's less open. This is saying that should be excluded then. And I believe this is what Dancey was saying, in that there's a whole variety of different licenses that the Creative Commons organization gives out. So these are these two-letter designations. So you say, Creative Commons -NC -ND, something like that, whatever. Modules would not qualify as open license. Okay. So the most obvious disqualifying features are those that restrict entire categories of use or activity by the licensee. Prohibitions on the commercial use of the licensed work or restrictions on the nature of the activities that the license can undertake, restrictions on using the licensed work in connection with a pharmaceutical or military research, violate the operational principle and its use maximization orientation. Similarly, restrictions on creating derivative works using the licensed content are disqualifying, as the provisions that attempt to mimic or replicate moral rights type restrictions on association or modification, such as prohibiting alteration of the licensed work without permission of the licensor, or prohibitions on the use of the licensed work in advertising or in association with a product, cause, or institution. Finally, prohibitions that restrict the availability of the license to individuals or entities based on their inherent personal characteristics or organizing principles also offend the operational principle and are thus disqualifying. So that does seem like, whole categories. Like, hey, you cannot use this for virtual tabletop, or you cannot use this for videos, or you cannot use it for whatever. This is, in order to be an open license, you wouldn't be able to restrict whole categories of uses like that. That's what that sounds like to me. Okay, conclusion. So this is, I think this chapter is one that, unless I see a highlight in, I think we can skip, because this is the indicatia of success, about whether or not in this research you can assess whether or not your open content was successful in stimulating creativity. Let's see. Oh, hey, PhD Tony. We're sitting here going over a doctoral dissertation, so join the fun. I got to talk to PhD Tony last night. Let's see here. He's a geophysicist, so we talked geography and remote sensing. Yes, I think this is my second. This could be basically my second most watched stream, and I think it's kind of ironic that the most watched stream was one where I read the leak of a legal document, and now the second one is here. I'm reading somebody's dissertation and analyzing it. Didn't know there was so much interest in legal documents and dissertation analyzation here in the Geekverse, but there is. All of a sudden, it becomes very relevant. All right, so let's go over here. Let me scroll down here. I don't see highlights here. I think that the documentation of, I respect what's been done so much more now and how important this was. And Ryan did talk about the skepticism that there was at the time. In the software community, people understood open content and open source stuff, but that wasn't something in the tabletop game sphere. And it took a lot to get people to realize that, hey, this is real. This is really what we're doing. And it is what it says it is. And there's not some kind of ulterior motive underneath it. This is why he's studying the OGL. So, okay, so let's see. Why is he studying this? That's probably good. However, the use of the OGL in connection with the Dungeons & Dragons gaming line and other RPGs represents something of a different order. Oh, wait, so let's go up here. The OGL warrants attention because it represents one of the few examples of open content licensing being used in a sustained manner in connection with a commercially successful entertainment product. There have been other examples of open content licenses being used in conjunction with various entertainment product releases, such as the release under Creative Commons licenses of novels by the writer Cory Doctorow, recorded music by the band Nine Inch Nails, and the card game Cards Against Humanity. Those innovative uses have been significant for the particular artists or publishers who use them in their audiences. Depending on the reputation or success of a particular person or product, it might be claimed that such uses indicate a viable alternative to traditional intellectual property management and licensing practices in the relevant segment of the entertainment industry. However, the use of the OGL in connection with Dungeons & Dragons gaming line and other RPGs represents something of a different order. Wizards of the Coast, the publisher of the world's most popular RPG, a game with decades of commercial and cultural success, which, even in unremarkable years, can generate tens of millions of dollars of revenue, elected to release their flagship product using an open content license, copyright license, in a deliberate effort to not only revive the commercial fortunes of the game, but to spur innovation in the industry, which they were in the dominant provider of creative product. The OGL has been in use since 2000, and Wizards of the Coast has released 2 different editions of the D&D game using the OGL, 3rd edition and 5th edition. Right, okay, so that's why we're studying what makes this unique and why it's worthy of study. Let's, I don't think this chapter is going to be particularly relevant unless I see a highlighted something that I got from notes earlier. Otherwise, we will get into chapter 6. Okay, the history and the mechanics of the open game license. Let's see. Judy says, yeah, there are already a lot of lawyers who play this. And I'm sure, like I said, I put out on Twitter, I said, you know what's happened here? That, excuse me, since Thursday, thousands and thousands of geeks who all love rules, rule books, and rules lawyering were suddenly told there's a potential flaw in the wording of a 22-year-old Dungeons and Dragons license. And everyone has descended upon that, right? That's exactly the kind of thing that this group of people would like to be able to adjudicate and get into. Hence, I suppose, this live stream and its popularity here and everything we've been talking about. So, okay. So I think this chapter, I don't think it's all that long, but I think this is an important one, especially if we're interested in this kind of topic, that this is the core one that talks about especially the mechanics, how it operates. So we're going to become experts here in the mechanics of how this open gaming license, specifically, the open gaming license specifically, not that we just got our education on open content in general, but how this particular license operates. Okay. Okay, let's skip over the introduction. D&D and RPGs. A brief backgrounder. D&D was first commercially released in 1974 and was the pioneering entrant into a new form of game called tabletop role-playing. RPGs may be usefully characterized as multi-participant storytelling. Well, we know that. Beginning with saying, okay, we probably didn't get into the history of Dungeons and Dragons. Let's get to where we started having the open gaming license. Because of their multiplayer nature and the manner in which participants are called upon to interact with creativity and creatively contribute to the rules, RPGs and their play resonates with the communicative copyright framework being used in this dissertation. And, Ryan Dancey was talking about the value of your RPG is the number, like your rule system, is the number of other people who understand how to play it. So the more people who understand how to play it, the more valuable it becomes to both like a company, but then also to you, because you've got access to more people who would like to play it. Hey, and maybe we're trying to increase the networks of other RPGs. That's exactly what we're doing on the morning grind in the mornings. When we're looking at different RPGs, we're giving people a format where they can come and learn something about different games and increase the network surrounding different games, and therefore increase its value. Value for the company, but specifically we're talking about here value for people and players, because other people will know more about how to play those games. Okay, we got know what an RPG is here, people. Our people do. The people reading his dissertation probably did not. Let's get to... Okay, all right, so here we have the history of the open game license, which is really what we're concerned with here. The road to the open gaming license. So, for most of the first 3 decades of its existence, D&D was published by TSR, Incorporated, beginning in the 1970s and continuing to the very early 1990s. D&D represented not just the pioneering entry into a new category of entertainment product, i.e. the RPG, and not only was it by far the most popular example of that product, but there were stretches in which the game was a genuine popular cultural phenomenon. In the 1980s alone, D&D spawned a Saturday morning cartoon, which ran for 3 seasons, and a moral panic rising from the suicide of a university student that was blamed on the fact that he played D&D. In 1982, CBS aired Mazes and Monsters, a primetime movie of the week starring Tom Hanks, and in 1985, 60 Minutes devoted a segment to exploring whether or not D&D was a dangerous to the moral and mental health of its players. And playing D&D is a recurrent element on The Big Bang Theory, currently broadcast broadcast television's most popular sitcom. This was back in 2019. For the first 20 or so years of its publication, from the first copies mailed in the 1974 from the living rooms of its co-creator Gary Gygax and Dave Arneson, to the sprawling product line that developed in the wake of the release of second edition in 1989, which was carried in book, toy, and hobby shops around the world, D&D was a steady source of income for its owners and by far their most lucrative products. TSR, now this is what came up that I didn't know about until all this started, but people have been telling me in the comments. TSR had long been seen to be an aggressive enforcer of its intellectual property rights. Indeed, the company had gone so far as to sue its co-founder, Gary Gygax, for copyright infringement after he departed the company and tried to publish competing RPGs with other publishers. That's incredible. Throughout the 1980s, TSR had sued or threatened to sue competitors and even players who published gaming materials which were expressly designated as being compatible with D&D. Oh, and we just talked about that as far as compatibility with trademarks. So they sued or threatened competitors and even players who published gaming materials that were expressly designated as being compatible with D&D. By the mid-1990s, with the community of RPG gamers enthusiastically moving into a nascent online world, TSR's attempts to enforce its copyright and trademark rights against gamers who shared fan-created material had earned it the sobriquet, I believe that's how you pronounce that word, $R, and prompted long-running online debates about the extent of TSR's intellectual property rights. TSR's position on online fan content have been described as adversarial. The company routinely, if understandably, objected to websites hosting online files that contain digital copies of entire TSR published works. But they also voiced objections to websites and files containing excerpts from published works, and even to entirely new player-generated content containing elements of our copyrighted properties, including characters, settings, realms, realm names, noted magic spells, elements of the gaming system, such as armor class, hit dice, and so forth. Despite its historic commercial success, by the mid-1990s, TSR was in dire financial straits. These troubles were the result of a mix of fiscal and popular culture stresses. One of the major causes was a pronounced and durable shift in gamer preferences from tabletop or pen and paper RPGs like D&D to computer and console-based games and to collectible card games, CCGs. CCGs was the most popular of which was Magic the Gathering, released in 1993 by Wizards of the Coast, used decks of pre-printed cards similar in size and shape to baseball cards, and attracted enormous amounts of attention and gamer spending away from traditional RPGs. A second major cause related to the first was the financial impact of massive amounts of returned inventory from book retailers who had overestimated the continued popularity of traditional RPGs and RPG-inspired fantasy novels in the face of the new CCG craze, which developed in the wake of Magic the Gathering's success. A sustained run of poor business decisions by TSR management and ownership increased financial strain on the company. Notably, TSR overpaid for licensed content, alienated popular writers, and published an overabundance of gaming and gaming-related products, which resulted in a market glut and decreased revenues. By the end of 1996, the company was $3 million in debt. I didn't know that. The company was $3 million in debt. I knew it was bad. I've been hearing that it was bad, but I didn't know it was that bad. It was $3 million in debt, and numerous potential purchasers were considering acquisition. In 1997, imagine being $30 million in debt. And of course, that's in 1996 too. So you got to remember $1996, $30 million in debt for publishing Dungeons and Dragons, by publishing Dungeons and Dragons. Wow. In 1997, Wizards of the Coast, riding a wave of success from its customizable card games, purchased all of the assets of a floundering TSR for an undisclosed amount. 2 years later, in 1999, Hasbro, that was only 2 years later? So that happened much faster than I remembered. 2 years later, in 1999, Hasbro, one of the largest toy and game producers in the world, purchased Wizards of the Coast for a reported $325 million. What? Billion? Billion. Whoa. 325 billion? Is that number right? The purchase price is approximately $477 billion in inflation-adjusted dollars, inflation-adjusted 2017 dollars. Whoa. Let me go to the chat for a moment. Let's see what's going. What are people saying here? A lot of us here are making our own tabletop RPGs. Now we can discuss fragmentation, because I think there are several that are going on. Lots of people are making them, whether or not 1.0A stands or not. Already there are a lot of initiatives to create more completely open RPGs. Now, not all of them will be successful. Obviously, the community will probably end up adopting some or all. I mean, not some or all. Some or maybe none of them. But we could have a fragmentation issue. But we'll have to see how it all shakes out. Hopefully, the cream will rise to the top. That's million, thousands. Oh, it is millions. It is millions. Yes, thank you. Yes, it is million. I thought, how in the world can that possibly be possible? Yes, perhaps I'm getting too tired here. So that is 325 million. 325 million. That would be 477 million. I was like, how does that even square with the numbers that the acquisition of D&D Beyond or something like that? Yes, so not 325 billion. Not that. Thank you. Yes. Let's see here. Yes. Hey, Retro Nerd Girl. Good to see you. Good to see you. Shortly after purchasing TSR's assets in 1997 for $325 million, and with the second edition of D&D nearing its 10-year anniversary, WotC turned its attention to the development of a new edition of the game in an effort to revive the brand following its displacement at the front of the gaming industry by CCGs. The third edition of D&D, retroactively dubbed and referred to in this chapter as 3.0, was released by WotC in 2000. And Ryan Dancey said that there was nothing that was happening in the rule set was dependent or being caused by the open game license or vice versa. The idea that this was going to happen was not part of the rules development of the game. Those were separate projects. Although WotC, was wholly owned by Hasbro evidently adopted something of a hands-off approach to the development and release of 3.0, given the process was far advanced by the time of the acquisition. Oh, so interesting. So that was being planned by TSR. So, but nearing its WotC turns attention, the third edition was released by Hasbro. Although WotC was wholly owned by Hasbro, Hasbro was hands-off. Okay. Containing the revamped game mechanics, dubbed the D20 system for its reliance on using the icosahedric 20-sided die as its core gaming mechanic, was one of the transformational aspects of 3.0, and it was released in tandem with the OGL, an open content license created specifically for third edition. The OGL was one component of three related but discrete aspects of Wizards of the Coast 3.0 release system. So the D20 system, we can't forget about that because we've got rule books and books that have the D20 system logo on it, right? Which was different from Wizards of the Coast, Dungeons & Dragons. D20 system had its own logo. And OGL and its associated, the OGL, so one was the D20 system, the OGL and its associated system reference documents, and the D20 trademark license. Each of these elements and interaction between them requires further explanation. So I would like, this is good because I would like clarification on that, because I believe there's something about that being challenged and lost, right? And while the other ones remained. The D20 system was a reconfiguring of the D&D rules to streamline them and unite them around a core gameplay mechanic, using the 20-sided die as the main device for assessing success or failure within the rules of the game. Previous editions of the game had made promiscuous and haphazard use of various multi-sided dice in gameplay. Only devotees of the game knew when a 6-sided die would be needed as compared to when a 4, 8, 10, or 12-sided die would be required. Hey, that's a unified action resolution mechanic. We've been talking about those when we've been talking about RPG development on the morning grind, specifically on Tuesdays, and we've been looking for, when we're trying to learn how to play RPGs, what is their core action resolution mechanic, and hopefully they have one and are not relying on something very haphazard and arbitrary like had been previously. That is, to me, an advance. That's actually advancement in RPG, shall we say, technology. That's actually advancements that's made in tabletop gaming, I think. 3.0 consolidated, not that it was the first one to do that, but not that this was the first one to have a core action resolution mechanic. but it's was the big one, right? Because of the brand. While under the hood, so 3.0 consolidated the most dice-based activity on the 20-sided die. While the under the hood, the revision of the rules was fairly dramatic, the game still looked and operated much as it always had. It was still a tabletop fantasy RPG that made use of elements already present in the original 1974-79 editions of the game, and someone who had played this game in the late 1970s would have little difficulty picking up the new rules or recognizing the game that was being played. Although the D&D rules had been streamlined into the D20 system, they nonetheless still filled hundreds of pages spread across the 3.0 Player's Handbook, Dungeons & Masters Guide, and the Monsters Manual, which itself was nothing new. The 1977 first edition of AD&D also occupied hundreds of pages of rules. The OGL was designed to operate in conjunction with the D20 system, i.e. it was intended to make the D20 system open by granting access to the D20 system. That access was enabled by a separate component, the release of the text of the D20 rules in the SRDs. While the printed 3.0 rulebooks were hardbound books containing lavish illustrations, WotC also released the SRDs, rich text formats, RTF, files containing stripped-down expressions of the game rules. In effect, the SRDs were the source code of D&D. The SRDs were made available online and remain free to access and download. Making available the SRD, then, is the equivalent of the open source approach for providing access to the source code of a computer software. The SRDs were made available under the terms of the OGL, an open content license that permitted reuse of the materials contained in the SRD, and the condition of compliance with the OGL. The mechanics of the operation of the OGL are examined in further detail in part 4 of this chapter. So we will get into that. Yes, thank you. Thank you. Million. Yep. Andy says, I'm a fan of generic rule systems and then applying them to different game worlds. Retro Nerd Girl, by the way, does your channel have an official Instagram account? It is out there. So she'll be able to point you to it. Yeah. It did not sound right as I was saying that. That would be creating some serious wealth with tabletop RPGs. Okay. Let's see. So where are we? Okay, finally, the D20 trademark license permitted the use of Wizards of the Coast registered D20 system trademark to indicate compatibility with the D20 system. So that was the emblem you were supposed to use, which ideally, I suppose that was the initial fix to our 5e emblem, not really problem, but multiplicity. The D20 system trademark itself was simply a stylized text box that included the words D20 system and was intended to be placed on the covers of publications to indicate the gaming product used the mechanics of the D20 system. By using the D20 trademark license, other RPG publishers could publish RPG material that was expressly marketed as being compatible with the D20 system that underlay the new 3.0 edition of D&D, the world's most popular RPG. The D20 trademark license was supplemented by the D20 System Trademark Guide, which contained detailed guidelines for the use of the mark, ranging from the required statements of compatibility with Wizards of the Coast D&D publications. For example, licensees were required to include in certain statements on the front and back cover of their publications, such as requires the use of the Dungeons & Dragons Player's Handbook, 3rd edition, published by Wizards of the Coast. I remember that, because that was what they were, let's sell players' handbooks. You get this, but you've got to have a player's handbook in order to play. To required font and logo and font sizes, the logo must be 1 inch in width by 1 inch in height. The text of required statements must be no smaller than 10-point and no larger than 12-point font. From the first version, the D20 trademark license, in conjunction with the D20 System Trademark Guide, also imposed restrictions on the content of gaming products which could be created and branded as the D20 system. So that, I think that's what becomes important. From the first version, the D20 trademark license, we're not talking about the OGL, we're talking about the D20 trademark license, in conjunction with the D20 System Trademark Guide, also imposed restrictions on the content of gaming products which could be created and branded as D20 system products, which is different from saying they could be OGL, right? One significant restriction prohibited such products from containing rules or character creation and advancement. I remember that being a big thing. You couldn't talk about how to create a character. because the character creation guides were supposed to be the player's handbook. You were supposed to have the player's handbook for character creation and advancement. The creation and advancement rules are foundational to any RPG game-playing experience. They enable a player to define a character that the player will be using in the game world and provide a mechanism for the character's persistence and advancement through multiple sessions with the application of experience points to the character's defined abilities. Okay, yes, we know what that is. Essentially, the rules by which a character becomes stronger and more powerful. Without such rules, a gaming product could not be considered a full game by usable by players. So that was the intention. You can't publish a full game and be using the D20 trademark. A gaming product could not be considered a full game usable by players. Thus, through that restriction, the D20 trademark license functionally prohibited licensees from creating complete tabletop gaming products which could compete with D&D and still use the D20 system branding. That was the mechanic there. The three different components, the D20 system, the SRD, the OGL, and the D20 trademark license, were intended by WotC to operate as follows. A non-WotC publisher, the intention, a non-WotC publisher could use the OGL to obtain a license to use the OGL system, to obtain a license to use the D20 system rules that were contained in the SRD, and in reliance on the content contained in the SRD, create new RPG gaming materials that could be marketed and sold subject to compliance with the terms of the D20 trademark license as being compatible with the D20 system, and hence the third edition of D&D. But what you're saying you're compatible with is the D20 system. In other words, WotC anticipated that the OGL and the D20 trademark license would be used in tandem by publishers. Those publishers would create materials such as gaming supplements and adventure modules that WotC viewed as less profitable than the core rule books of the game. Right, and there were tons of modules and everything like that published. That being said, it was not necessary to use the SRD, OGL, and the D20 trademark license in tandem. As described in more detail in part 5 of this chapter, use of the OGL is not conditional upon the use of the D20 trademark license. Use of the OGL is not conditional upon the use of the trademark license. Licensees are free to use the SRD, OGL to create gaming products without the use of the trademark license. While the D20 system was created in conjunction with D&D's 3rd edition, WotC itself also adapted it for use with other RPGs. They released a D20 system for Star Wars RPG in 2000, which I remember playing quite a bit, and 2 other genre RPGs, including D20 Modern, which I did play once or twice, and D20 Future. I did not know there was D20 Future. Never played that one. I need to grab a drink of water. I'm just going to, my cup is empty here, and I need a drink. So I'm going to grab some water in this cup, and then I will read some comments, and then we'll get back to it. Just one second. Let me get some water. All right. Now I can hydrate. Thank you for staying with me. Let's see. Piano brings up GURPS and Fallout. I've never played Fallout, but I played a lot of GURPS. It seems like I should have played a game that was based on GURPS, but I never have. Oh, yeah, yes. Anybody remember GURPS? GURPS was my favorite RPG for a long time. You can see the GURPS book sitting behind me. Played a lot of GURPS. That was my favorite system for a long time. Okay. I think about GURPS, Fate, and Hackmaster quite a bit, especially in terms of trying to design a game. GURPS, Fate, and Hackmaster. Read a bunch of other things too. But I think about those quite a bit, especially in terms of game design. Okay, so we are continuing here with the read-through of the dissertation that was written on the OGL back in 2019. So not all that long ago, 2019, this dissertation in IP law was written on the OGL. And so we're basically going through the history of the OGL, and we're talking about specifically right here then the difference between the D20 system and its trademark and the OGL stuff. So C, WotC's motivations and rationale for the creation of the OGL. Oh, look, we're bringing up Ryan S. Dancey, who we heard from today. The OGL has been described as the brainchild of Ryan S. Dancey, a corporate vice president and brand manager for Wizards of the Coast, who is credited with the initial conceptualization and even the drafting of the OGL. In describing the origins of what he dubbed the open gaming movement, Dancey explicitly identified Richard Stallman, generally recognized as the founder of the free software and open source movements, as the source of inspiration. In an interview with Dancey published prior to the release of D&D's 3.5 edition, Dancey cited GNU's general public license, the pioneering open source license of the Free Software Foundation's GNU project, as the foundation of an ongoing attempt to create a similar license for gaming. Dancey noted various similarities between software development and RPGs. He described them as both complex systems using standardized protocols and interfaces that are shared by many people, with many independent subcomponents that have worked together. The trifecta of components that made up D&D's third edition, the D20 system, the SRD, the OGL, and the D20 trademark license, originated in Dancey's belief that the strength of D&D was not in its game system, but instead in its gaming community. And he talked about that today, the set of people who actually played the game. Business considerations played a prominent role in Dancey's innovations. His view was that the proliferation, and remember, he took over when D&D was in a disaster of a state, or TSR as a disaster of a state from a business perspective. So business considerations played a prominent role because he was charged with trying to fix D&D. What went wrong at TSR and how do we fix it? So business considerations played a prominent role in Dancey's innovations. His view was the proliferation of competing game systems was detrimental to the RPG industry because it fragmented gamer attention and dollars. $20 spent in a gaming supplement for, say, the competing game Ars Magica was not only $20 that could not be spent on D&D, but was lost from the point of view of the D&D community because the Ars Magica supplement would have little or no cross-pollination with D&D due to the incompatibility of the underlying game systems. If, however, the underlying mechanics of all games could be unified into a single adaptable system, then all gaming supplements would functionally contribute to the viability of an ever-increasing market of RPGs. Dancey expressly mentioned what he described as the theory of network externalities, which he talked about today, according to which the value of a product is dependent on the number of users of that product, hence the desire to create a unified mechanic, the D20 system. Dancey also believed in the truth of what was referred to within WotC's as the SCAF effect, named after WotC's staffer Scaf Elias. The SCAF effect was the belief that the market leader for tabletop RPGs, WotC, would only benefit from the success of other RPG publishers. So who was that? The SCAF effect. I didn't know this had a name. The SCAF effect. The WotC would only benefit from the success of other RPG publishers. In short, the SCAF effect predicted, and we had a word for that. We've just we didn't name it, but we found the word for something. The SCAF effect. I like that. Well, actually, and Dancey talked about that on the stream today. Piano was talking about, so they had the OGL created to ensure that D&D would never be at risk of disappearing ever again. And it allowed 5th edition or people to come back to 5th edition. Like, what was that? Because people were playing Pathfinder, but he said people would rather be playing D&D. So rather than trying to get people back to the table, they already were at the table. They were playing Pathfinder. So the OGL is what allowed 5th edition to become what it became because they weren't trying to attract people back to the table. They were just trying to get them to change what books they were playing. And potentially books they wanted to be playing with anyway, the D&D brand. So in short, the SCAF effect predicted that people who became gamers via an RPG other than D&D would almost inevitably eventually become players and hence purchasers of D&D products due to its overwhelming market presence, and that transition to D&D would be eased if the games all used a unified mechanic. A rough analogy can be constructed to traditional 52 playing card deck manufacturers, i.e. card decks containing suits of hearts, spades, clubs, and diamonds. If you are a card manufacturer, you have an interest in fostering the development of multiple different card games that use the 52 card deck, from solitaire to bridge to poker to blackjack and so on, because as new games are developed or become more popular, players of those games will continue to need to purchase more of these decks. Combining all of these considerations led Dancey to the conclusion that the optimal strategy for D&D was to ensure that all RPG gamers were using the same underlying gaming system, the D20 system, but also to open the D&D rules themselves to others. He described it such an open access. As he described it, such an open access approach would lead to rapid, constant improvement in the quality of the rules, with lots of people able to work on them in public. Problems with math, the ease of use, a variance from standard forms, etc., should all improve over time. The great thing about open gaming is that it's interactive. Someone who figures out a way to make something work better, and everyone who uses that part of the rules is free to incorporate that into their products, including Wizards of the Coast. We only 5 viewers. I see we've got 97 total viewers right here. I don't know if I can do shots today. We got 97. I wonder if we can hit 100 total views. That would be crazy if we did. 100 views for reading a doctoral dissertation. It's more people than showed up to. Well, it's way more people than showed up to most doctoral defenses. It's way more people than showed up to mine. In a marked move away from the position adopted by TSR, the previous owner of D&D, Wizards of the Coast adopted the stance that D&D rules themselves should not be the focus of enforcement activity. We want to use the trademarks of D&D to hold the value of the business rather than the rules themselves. Right. So the D&D, the rules themselves should not be the focus of the enforcement activity. We want to use the trademarks of D&D to hold the value of our business, not our rules. This appears to be a reference to the use of the dual licensing strategy noted in Chapter 4, WotC made the D&D rules. In Chapter 4, WotC made the D&D rules in the form of the SRDs, which is essentially text-only Word files available for free download and sold at retail high-quality printed books bearing the D&D logos. In other words, consumers could get stripped-down versions of D&D rules for no cost, and could purchase D&D compatible content created by third-party publishers who use the OGL, but official D&D products would remain the exclusive provenance of Wizards of the Coast. In Dancey's conceptualization, the D&D game itself, conceived of as a creation separate and apart from the trademarks associated with it, should benefit from the shared development of all people who work on the open gaming derivations of D&D. Dancey was explicit that he wanted and expected the OGL to result in the creation of new D&D content authored by Wizards of the Coast competitors. He wanted to let other publishers create supplements for D&D and to incentivize the creation of more D&D compatible products. Such an opening of the D&D network to infusions of D&D compatible content from creators outside the walls of Wizards of the Coast required an explicit pivot from the IP enforcement policies pursued under TSR. The OGL itself was to be both an instrument and the symbol of the changed approach. One of my fundamental arguments is that by pursuing the open gaming concept, Wizards can establish a clear policy on what it will and will not allow people to do with its copyrighted materials. Just that alone should spur a huge surge in independent content creation that will feed into the D&D network. And he was trying to do that by making it ironclad and bulletproof that here you have permission to do these things and you're not going to have it taken away. This is what we're doing. And he then so brought out the OGL. There were also perhaps self-serving motivations articulated. Concerns about freedom of expression were cited, though such articulations are consistent with those voiced by the open source advocates who inspired the OGL. Open gaming is a recognition that your natural human right to free speech is protected and enhanced. The open gaming system is a way for the tabletop publishing industry to finally deliver on the basic promises made by the very first RPGs, that individuals should be free to copy, modify, and distribute their own creative works derived from the game systems that they have acquired. In addition, what were described as business-related reasons were set out. Notably, in the explanation is the emphasis on the value of the trademarks and brands associated with the RPG product and the use of the open content license to drive value to the owners of the marks and brands. So this is the Q&A. Is there a business-related reason to support open games? Answer. In the case of companies who own trademarks and brands associated with large player networks, one school of thought holds that open games which link those large networks will tend to reinforce them and drive value to the owners of those trademarks and brands. That is the primary reason that Wizards of the Coast, as a company, is supportive of the open game concept. It fully expects that it will gain a direct financial reward in years to come from the widespread positive effects that the open gaming will have on RPG properties, specifically on the sales of Dungeons & Dragons materials. Of course, the flip side to that theory is that if it is successful because other publishers have also been able to extract value from the network of players through the sale and promotion of their own open gaming product lines. There's wealth and money generated for everybody involved. Thus, at the same time, the large owners of game network trademarks and brands stand out to benefit greatly. So do smaller companies and individuals who simply want to sell their work to the largest possible audience of consumers. Okay, what has this impact has been? And I think that I'm seeing that he's breaking this down into phases, and I think these phases are interesting. D&D was made before HeroQuest. Yes. Hey, Synth Weasel. Good to see you. Oh, books going into storage, I see. Yeah, there's a lot of stuff that's being sold right now. It's great, all kinds of sales going on. It's a great time to get 5th edition stuff from publishers. Okay, so what is the impact of the OGL? Describing the history of the OGL after its release in 2000 is best accomplished by separating out and focusing on 5 overlapping phases. The years 2000 to 2003, during which the OGL was used by third parties in a manner consistent with the expectations of WotC, in conjunction with the SRD and the D20 trademark license, and primarily to create D&D supplements, particularly in the early portion of the era to create adventure modules. And I just remember the number of adventure modules just being everywhere. They were everywhere. 2, from 2003 onward, a period in which the OGL was used entirely apart. Oh, I guess I should say, because I always forget here, but hey, some people may be calling out in the chat, and I really appreciate it. But if you're here, we got 97 people here. I don't know how many likes or we have on the stream yet, but if you haven't, please hit the like button, and please do subscribe if you have not already. It would really mean a lot. I would really, really appreciate it. I was asked last night if I'm going to be doing something like channel memberships, and I don't have like channel memberships enabled or yet, but I'm thinking about that. Let me know your thoughts on that. I'm trying to think of, I've got to look up what the benefits of the channel membership would be and what I would do with that. So I'm thinking about that. I was asking about that. So I'm thinking on it. If you have ideas about that, let me know. It's something I got to think about, but I haven't been able to think about it in the last 4 days because of all the streaming and what's been going on here. So, okay, so we got 3 different phases. So that was phase 1, 2000, 2003. From 2003 onwards, a period in which the OGL was used entirely apart from the D20 trademark license and instead in conjunction with the publication of standalone games which competed with D&D in the RPG market. Beginning in 2006, the use of the OGL by multiple publishers to create retro clones or recreations of old versions of D&D, which directly compete with D&D in the fantasy RPG market. And the creation of the retro clones, that was really interesting, that Ryan Dancey said that he did not anticipate the creation of the retro clones. It was one of the things that surprised him. He said not a lot of uses of the the OGL and the SRD had surprised him, but the creation of the retro clones had. He wasn't against it. He was just saying that it was surprising to him. 4, beginning in 2008, the abandonment of the OGL by WotC in connection with the release of Dungeons & Dragons 4th edition, followed in 2009 by the use of the OGL by Paizo, publishing to create the Pathfinder role-playing game, which became D&D's largest competitor in the RPG market. And 5, finally, in 2016, the readoption of the OGL by WotC in connection with the release of Dungeons & Dragons 5th edition phase. Each of these phases will be discussed in turn. So use as intended, 2000 to 2003. The creation and release of the D20 system, the OGL, and the D20 trademark license marked a decisive turning point in the history of the RPG industry. Indeed, the new approach indicated by these devices was that such a departure from the previous IP enforcement approach of industry heavyweight TSR that some publishers initially thought that it was some kind of trap. Right, yeah, right. That is this real? As described in Part 3, the previous owners of D&D had engaged in aggressive enforcement activities, even going so far as to sue competing publishers who published material that was described as compatible with D&D. But WotC was evidently committed in good faith to abiding by the spirit of the OGL and Dancey's public statements about open gaming, and the result was a renaissance in RPG gaming that saw the release of numerous new RPG products. Hundreds of new companies cropped up in response to the OGL. From the initial years following the release of the OGL and the D20 trademark license in 2000, it is difficult to separate out the effects of the SRD and OGL, which enabled access to D&D's source code contained in the SRD, from the effects of the D20 system and the D20 trademark license. For the initial years, it's difficult to separate those, as it appeared that most publishers elected to make use of both the OGL and the D20 trademark license simultaneously by releasing products that were expressly designed and marketed as being compatible with D&D 3.0 and the D20 system. Regardless, the immediate impact was obvious. Within a year of the release of the SRD, OGL, and a number of publishers exhibiting D20 system products at the RPG's largest annual trade show convention jumped from 3 to an estimated 75. Wow. The industry experienced a D20 boom that entailed the publication of hundreds of D20 system-compatible supplements, and D&D's third edition was an unqualified commercial success. Ryan Dancey had stated that in 2000, the year when D&D 3.0 was released, the Player's Handbook alone was selling more copies in a single month than the second edition sold in all of 1989, the year of its release. Wow. In 2000, the year 3.0 was released, the Player's Handbook alone was selling more copies in a single month than second edition sold in all of 1989, the year of its first release. That's incredible. So that's success. That is some serious success. Further, Dancey has described the OGL as an integral aspect of the revival of D&D's fortunes. The most important thing to know about the history of the OGL and what succeeded it in the primary goal, which was to help relaunch Dungeons & Dragons, D&D returned to its place as a successful and profitable business, in part because of the OGL D20 project. This project was not the sole reason for the restoration of the business, but was an integral part of a very complex plan. So, instrumental usage, 2003. In 2003, WotC took steps which fundamentally altered the OGL D20 system landscape. Unlike the OGL, the D20 trademark license was both revocable and amendable, and it imposed restrictions on the nature of gaming products that could be released bearing the D20 mark. So, this is important, unlike the OGL, completely different thing here, the D20 trademark license was both revocable and amendable. Well, unlike the OGL, there we go. We're telling him right there in this dissertation, OGL, not revocable. But the D20 license was. So that would be interesting. We could also compare the license. I don't want to do that today. But you could go back and compare the text of the D20 trademark license to the OGL and say, hey, the D20 trademark license has a lot more restrictions and can be revocable. And here's what you can do with it and what you can't. And it also imposed restrictions on the nature of gaming products which could be released bearing the D20 trademark. The latter feature meant that if anyone using the D20 trademark license was barred from creating a complete game capable of competing with D&D by supplanting it. You can't do that if you're using the D20 logo. In 2003, WotC revised the D20 trademark license to require that all materials released under the D20 trademark license meet community standards of decency, as determined by WotC. The change was made in order to stymie publication by Valar Project, Inc., of the controversial Book of Erotic Fantasy, a sexually themed supplement for D&D. I don't have the Book of Erotic Fantasy. Anybody have the Book of Erotic Fantasy? Is that one we should get and look at on the morning grind one day? I don't know. I have no idea what's in it. But at any rate, I remember when that controversy was going on, because I remember this happening and the publication of this book, the Book of Erotic Fantasy. So what happened here? Valar, relying on the irrevocable OGL, ultimately published the book, dropping the use of the D20 trademark license. What this meant practically was that the content of Valar's book was largely unchanged in the context of erotic fantasy. Okay. It was unchanged. But the book and its marketing materials did not contain any reference to the D20 system or use the D20 marks and was not identified as being compatible with the D20 system. Around the same time, WotC made a decision to release a new edition of D&D dubbed 3.5. The move was made with little announcement, leaving many other OGL publishers angry due to the fact that their product schedules continued to be geared toward 3.0 D&D, which made them passé in what had become a fast-moving RPG market. Oh, Lunar Firefox says that I owned that book and it looked and I owned that book and it looked interesting. Mute says I didn't have it, but I remember it. I think one of my friends had it. I remember all the controversy about it. Is it on my way to get it? Opening up Amazon real quick. Yeah, it's still out there someplace. Oh, Heat Shield says, what dedication to this? To push through a document like this deserves a big like. Thank you. Yeah, like I said, you guys give me energy. I have no idea how long what time is it? It's nearly 6 to 9, but I do want to finish this. I feel like I've started, so I want to finish this. This is so, lots of people would not read through this, but they might listen to it. And I think this is important information. We're all getting more educated about what's going on in the world of tabletop gaming and open RPGs. Yeah, we are 2 hours in. We're 2 hours in here. I don't think this section is much longer, and I don't know what else. I don't know what else is relevant after this section. I guess we will just have to see. Needs more likes. Thank you, Piano. At the end, if we could get to see, I don't know what kind of record can we break. I don't know. The longest live stream has become 7 hours and 20 minutes. That was last night, so we're not going to break that one. Due to the fallout from these events, after this situation with the release of 3.5, due to the fallout from these events, which demonstrated to publishers that the newly amended D20 trademark license tethered them uncomfortably to content-related decisions made by WotC, use of the D20 trademark under the terms of the D20 trademark license dropped off precipitously after 2003, with many publishers switching to use the D20 system rules solely by relying on the SRD OGL and ceasing to brand their products as compatible with the D20 system. I also remember that. I mean, everything had that D20 trademark on it. And then all of a sudden that dropped. So that's why. Nonetheless, D&D remained a successful product line even 5 years after the release of 3.0. In 2005, it was estimated that the D&D line of products was grossing between 25 and 30 million annually. As realization spread that they could continue creating materials using the OGL without also using the D20 trademark license, so that was probably idea here. Wait a minute. These are 3 separate things, and they work together in this way, but we don't have to use them in that way. Once that realization started to get made, competing publishers created not just, and I think that was when I was talking about you can't un-OGL, I think it was related to this, because you can revoke D20 system. D20 system was revocable, but you can't un-OGL. That was the way it was. Competing publishers created not just relatively small-scale adventures, but also longer-form source books, campaign settings, lengthy descriptions of worlds and scenarios through which games can be played, and even new games that directly competed with the D&D game, something that had been effectively prohibited by the D20 trademark license because of its restrictions on products, including character generation provisions. But if you're not using the D20 trademark, then you can now tell about how to create characters and do whatever you want to in regard to that. Multiple games using well-known fantasy and science fiction brands were published using the OGL. Warcraft, the role-playing game, based on the hugely popular online game. Babylon 5, based on the popular sci-fi series of the same name. And EverQuest, based on the popular online game. White Wolf Publishing, estimated at one point to have a 25% share in the RPG industry. Oh, whoa. And White Wolf was quite large there. Made enthusiastic use of the OGL, publishing dozens of OGL-related gaming products in 2000, many of which competed directly with the D&D and almost none of which used the D20 trademark license or referred to their compatibility with D&D. At this point in the history of the OGL, it becomes clear that there were two distinct ways in which RPG publishers could make use of the OGL. The first way of using the OGL, which I dubbed the conventional, involves a publisher using the OGL as a way of accessing the D20 system contained in the SRD. The form of use means that the gaming materials produced by the publisher consist in some measure of the D20 system or the other open game content material contained in the original WotC D&D SRD, such as making the use of the D20 system's rules for combat and spellcasting, and the new gaming material is intended, to a greater or lesser degree, to be used by consumers in conjunction with the D&D game. In other words, conventional uses are those that align with WotC's stated expectation that the material will be used to supplement their core gaming products. A second way of using the OGL, which I dubbed the instrumental, involves a publisher using the OGL as a means of making their content available on an open basis, irrespective of whether or not their content makes use of the D20 system or the WotC SRD. In an instrumental use, a publisher creates gaming materials, be it an adventure, a campaign source book, or an entirely new game system, and releases it under the terms of the OGL in a manner which is entirely divorced from any use of the D&D, the D20, or the D20 marks, such as Pathfinder. Well, yes. And Isaiah Welch says, by the way, I saw Mr. Dancey on the Roll for Combat's live stream earlier today. Good stuff. It was fantastic stuff. We talked about that at the beginning of the stream. I talked about that at the beginning of the stream because I watched that and then I started the stream after that. So if you're interested in commentary specifically on his stream, and I took notes during his stream about the things that were particularly relevant, I thought, to us, and the things that we discussed on this channel and seemed to have come up in the chats and the comments. I talked about that when we started off here. Well, it's GCW 1978 says, right, it's kind of crazy. And they talked about that on the stream as well. And it is crazy. So anyone else here like me that had no idea or cared the OGL was a thing until the threat that it would go away happened, right? It's just this legal document, right? This one-page strange legal document license that's in the back of all these books that we love. And it's just there, and it's been there for 20 years, and it's some legalese and whatever else. But then all of a sudden, that one page, if it's threatened to go away, all of a sudden everybody cares. Everybody in the world can know if you know D&D, everybody's going to know what the OGL is. So, the rise of retro clones, 2006. As described above, the OGL spawned the creation of numerous gaming products, from the anticipated adventures that players could use with the D&D game to longer source books, and even the entirely new games competitive with D&D. But perhaps the most unpredictable result of OGL was the creation of what are sometimes called retro clones. Understanding the retro clone phenomenon requires a quick recap of D&D's publication history, from the initial version of the game released in 1974 through the 4th edition released in 2008. What marked each new release of the game with increasing complexity and density. The 1974 release consisted of 3 undersized softcover booklets totaling 120 pages. By the time of the 2008 release, the core game consisted of 3 oversized hardcover books totaling more than 800 pages. But it's important to note that each new set of rules contained in succeeding editions were functionally iterations of previous releases. A player reading the D&D rules in 2008 could see something which is certainly longer than the rules in 1978, but its core, the 2008 version, would recognize as being premised on largely the same mechanics, though often embellished in different various ways, whereas earlier versions of the game, being comparatively underdeveloped, embodied a somewhat freewheeling improvisational dynamic, placing significant onus on the game master and players to resolve in-game complications on the fly. By the 4th edition, the design of the game had become increasingly granular and rigid, with complicated sets of rules meant to govern virtually every conceivable permutation of gameplay. There was a significant cohort of gaming community consisting mostly of older players who were not just interested in playing D&D, but were particularly interested in playing the versions of D&D they had played back in the 1970s and 80s. But those versions of the game were long out of print and difficult to obtain. RPG player Stuart Marshall happened upon a solution. Since the SRD contained all the rules for 3.0 and 3.5 D&D, and since those rules for 3.0, 3.5 D&D are, at their core, essentially just more complicated versions of the rules for prior versions of D&D, then it should be possible to use the SRD and the OGL to reverse engineer or deconstruct the rules in order to replicate the rules for a desired prior version of D&D. The analogy is imperfect, but it's akin to extracting the rules of straight poker from the rules of Texas Hold'em, or the rules from checkers from the rules of chess. In 2006, Marshall published Osric, the old school reference and index compilation, which recreated the 1977 first edition AD&D game. In relatively short order, more retro clones were released, each utilizing the OGL. Labyrinth Lord recreated the 1981 version of basic D&D. Swords and Wizardry, 2008, recreated the original 1974 version of D&D. And For Gold and Glory recreated a second edition AD&D game. These retro clones were part of fan-based movement dubbed the Old School Renaissance, and that was what we call OSR, the Old School Renaissance, and that was documented in online publications, including dozens of blogs and multiple fanzines. More than a dozen publishers identified themselves as members of the Old School Renaissance group. The publishers of D&D, as a result of the OGL, thus found themselves in competition with the resurrected version of prior editions of their own game, given new life by a community of gamers who, perhaps in part driven by nostalgia, sought out simpler, less involved rules with which to play. Oh, now we get to it. The abandonment of the OGL and the advent of Pathfinder. Yeah, Vision says, you never know how much you're going to love something until it's gone. I don't know. We've talked about it. Can Wizards of the Coast just drag this out in court? I don't know if they can. I mean, legally they probably can. But in today's world of social media, could they really decide as a legitimate strategy to just try to drag this out for years? I mean, with the uproar that's gone on over the past 4 days or whatever, and the amount of damage that's being done, if they drug it out for years. Right. The role for combat, right. And Blue Jay, this was their opinion, but Blue Jay says the role for combat stream indicated, and this was Ryan, that the license is so good that a judge could rule from the bench that 1.1 cannot deauthorize previous versions, making it so there are no lawsuits and delays. And more generally, even that just they do not possess the power. It's not that 1.1 can't do it, but that Wizards of the Coast / Hasbro simply does not have the power to deauthorize 1.0a. Let's see. So the abandonment of the OGL and the advent of Pathfinder. By 2008, many of the individuals, including Ryan Dancey, who had spearheaded the development of the OGL at WotC nearly a decade earlier, were no longer employed by WotC. As it undertook efforts to develop and release the 4th edition of D&D, there was a major change in the institutional chance of WotC with respect to the OGL. The 4th edition, released in 2008, abandoned use of the OGL and was released using a new gaming system license, GSL, that was significantly more restrictive than the OGL. An extract from the GSL's Frequently Asked Questions document gives a flavor of the new approach. What parts of Dungeons & Dragons is open game content? Answer, none. None of the 4th edition Dungeons & Dragons product line is considered open game content, made available to third parties through the open gaming license. Certain content from 4th edition is available royalty-free for specific uses subject to the GSL. The move away from the OGL to the GSL was credited in part to the departure of Dancey from Wizards of the Coast. And he did answer why he left the company on that stream. Because people asked him, why did you leave Wizards of the Coast? And because he said, when he was talking to his boss, he was saying that he had been tasked with revitalizing Dungeons and Dragons. Here's what the TSR situation is. Find out exactly what situation TSR and Dungeons and Dragons is in, because they had just bought it. Figure out what's wrong, fix it, and get D&D making money. And so he devised this plan and everything, and it was successful at that and succeeded at that. And then he said he went into his boss and said, now that I've accomplished that goal, where am I going, next with this company? What's my next task or whatever? And he said that his boss said, well, I think you need to look for your next task outside of the company. I'm paraphrasing. Look that up. It's in that Roll for Combat stream. So that's how that happened. So he departed. So he was like, well, okay, if I've got to need to look for my next opportunity outside of, my next challenge, another opportunity outside of the company, he did. And then he found a position outside the company. So the GSL featured major structural differences as compared to the OGL. In addition to mandatory licensing fees and restrictions to objectionable content, similar to those that had been implemented when revisions were made to the D20 trademark license, the GSL prohibited the creation of new games based on underlying mechanics of 4th edition. That prohibition avoided the specter of the 4th edition giving rise to the creation of games that competed with D&D using its own mechanics, which had been seen ever since to move away from the use of the D20 trademark license that began in 2003. Even more controversial was the inclusion of the GSL of a poison pill clause that was intended to obviate the function of the OGL. Oh, anyone who published material under the GSL was prohibited from using the OGL and surrendered any claim to being able to exercise rights under the OGL. I didn't know that. Learning new stuff all the time. Let me highlight that. The most controversial was the inclusion of the GSL of a poison pill clause that was intended to obviate the functioning of the GSL. So they weren't trying to revoke or deauthorize it, because I don't think they thought that they could. So instead, this was the plan that they came up with, apparently. Okay, if you publish material under the GSL, you are now prohibited from using the OGL and surrendered the claim to be able to exercise rights under the OGL. Can you do that? Many RPG publishers elected not to use the GSL at all, with one publisher describing it as a total unmitigated failure. Changes to the GSL in 2009, including the removal of the poison pill clause that forced users of the GSL to give up rights to use the OGL, were perceived by the industry as too little too late. D&D's 4th edition had been viewed in retrospect as generally unsuccessful, partly due to a reorientation of the rules to focus on the game, more on tactical combat, and what had been described as an aesthetic and mechanical sensibility that seemed targeted at video game players rather than traditional RPG players. I skipped 4th edition completely, and it didn't have anything to do with 4th edition specifically. I just wasn't gaming at the time. So I happened to miss all of 4th edition. So I know very little about it. I didn't know that that was something that happened even. The negative effects of the bungled 4th edition release were compounded by a new development, the creation of the Pathfinder role-playing game by Paizo Publishing. In 2007, Paizo Publishing, to that date primarily a publisher of magazines serving the RPG fan market, released the first of its Pathfinder adventure publications, a series of interconnected adventures for D&D. Notably, consistent with the industry trend described above, Paizo released its gaming supplements using only the OGL and not the D20 trademark license. Of greater consequence, in 2009, Paizo used the OGL to create and release the Pathfinder role-playing game in 2009. Pathfinder is a complete gaming system based on the underlying D20 system made popular by WotC's D&D 3.0, 3.5, and was designed specifically to appeal to those gamers who like 3.0, 3.5, and did not want to switch over to D&D 4th edition. Paizo updated and tweaked the rules, aiming for something akin to a version 3.6 or 3.75, rather than the complete overhaul of D&D's, represented by D&D's 4th edition. Pathfinder represented a new game, but it was one that was still recognizable as Dungeons & Dragons 3.0, 3.5. By 2012, the industry consensus was that Paizo's Pathfinder game was outselling WotC's venerable D&D, and the efforts of many RPG publishers were devoted not to creating materials to support Dungeons & Dragons 4th edition, but instead to support Paizo's Pathfinder. So you got this big switch. Lisa Stevens, the CEO of Paizo, has expressly credited the OGL for making the company's success possible. If Ryan Dancey hadn't had the crazy idea to create the OGL and then champion it through the halls of Wizards of the Coast, then I wouldn't have been able to have the success with Paizo has become. Paizo used the OGL to release Pathfinder. It's supplemented. Paizo's use of the OGL to release Pathfinder is supplemented by their active nurturing of an online community that creates additional Pathfinder content using the OGL. They have done so in part by creating 2 additional governance documents that exist alongside the OGL and speak to different types of activities carried on by the RPG community. As is discussed in further detail in part 4 of this chapter, OGL allows licensees to use the open game content of the licensure, but prohibits the use of the licensor's trademarks and any content that the licensure designates as product identity. In the RPG market, claiming compatibility with an existing game can be vital for the success of a gaming supplement. To enable such games, Pathfinder Role-Playing Compatibility License allows licensees to create new Pathfinder material using the OGL and expressly identify it as compatible with Pathfinder. To facilitate the access to their product identity, Paizo has developed a community use policy that permits their customers to create and make publicly available content that incorporates Paizo's product identity, so it is not, so long as it is not exploited for commercial purposes. That's interesting too. I didn't know about that. I want to check out the Paizo's community use policy. Not today. We should also look at the WotC fan policy. Not today. Those interested in making use of Paizo's RPG content thus have 3 ways that they can do so. By using the OGL on their own, in which case they are limited to open game content and cannot make claims about compatibility, but are otherwise free to use the licensed content in accordance with the OGL, including for commercial purposes. By using the materials released under the OGL in conjunction with a trademark compatibility license, in which they claim compatibility with Pathfinder game, but are subject to the constraints set forth in the compatibility license, or using content that has been designated as product identity in accordance to the community use policy, which restricts any use to non-commercial activity. So that's your 3 ways. The Paizo website hosts online discussion forums featuring hundreds of thousands of posts, and the website hosts an online retail store that stocks not only Paizo's own products, but also the products of other publishers who create materials using the OGL or the compatibility license. To a significant extent, during the period which WotC was stepping back from the OGL and its underlying philosophy and strategy, it was Paizo that delivered on Ryan Dancey's premise of how an RPG publisher should interact with its customers by means of a continued commitment to the OGL and the cultivation of an ongoing relationship with Pathfinder and its players. Like players and content creators. Readoption of the OGL. What's going on in comments? All right, Vision is saying they are locking it down to try to prevent the switch again. History doesn't defeat it, but it doesn't repeat, but it rhymes. In other words, to make the TTRPG community isolated, de-networked, and make systems in the space incompatible. Isaiah says, this is not the first time WotC has attempted to invalidate the OGL 1.0a, and I was not aware of that history. OGL, this is great for that reason. OGL 1.1 is basically revenge for anybody not buying or publishing under GSL back during 5e. So, yeah, GCW 1978 says, so this big issue we're having now is not new with the company. So this certainly makes it sound that way, doesn't it? With this history. Now, it was not an attempt to eliminate 1.0a, and it's probably it's pure speculation, but it'd be that like we can't. Like that's not something we're doing. We're not authorized. Like we don't have any ability to deauthorize that. It's out there. It's been done. So their workaround there was trying to do the thing with the GSL to prevent you from using the OGL. But nobody liked, not nobody. I mean, there are people who liked 4th edition. Like I said, I wasn't in on it. But that rule set, by and large, was rejected by the player base. So if they had made something that was really fantastic, if 4th edition had been something fantastic that was such an improvement over 3.0 and 3.5 that everybody flocked to it, other things would have happened. $50.50. Hello, good to see you. I'd also suggest that the success of Pathfinder at the time was also in part to 5th edition being a departure from the traditional game system and the lack of interest in that version. Yeah, it was a perfect storm. It seems like that everything, and I talked about that in a video where I said who will be the Paizo for 5th edition, and we talked about the different things that a publisher would have to have in order to make that happen. I mean, assuming you wanted to do that or whatever. But you have to have certain things. And also, the conditions have to be right. And everything hit right for Paizo and Pathfinder. Everything hit right for Paizo. Yeah, I've seen that discussed too, Severin. Not legal advice, though. The GSL attempt shows intent and inability that they could not revoke the OGL. Yeah, we'd have to figure out what their thinking was, which is, impossible. But I've seen that brought up. Yeah, I'd be interested in comparing that. Vision says this is why they're calling it OGL 1.1 rather than something else. But 1.1 just sounds like the GSL. So, yeah. Piano TM says Ryan Dancey talked about that too. Yeah, if one D&D is good, the problem is solved, and they wouldn't have to worry about it. If one D&D or 6th edition, whatever that is, the same thing. If you just make that edition so absolutely freaking fantastic that everybody flocks to it, and everybody has to be playing it, then problem solved without having to deal with the OGL, right? Yes. And see, they were publishers and they lost the Dragon magazine license at around that same time. So they were sitting there. And I got to talk one time with the head of publishing at Paizo about this, because he was like, what do I do? It's a really neat story. Like, what do I do? I just lost the right to publish these magazines. And I've got all these people here who publish these magazines. And if I tell everybody that I've lost the magazine publication, everybody's going to leave. What do I do? I need a new idea. And so the idea of Pathfinder and all of that came up. And then it sounds like, we said, all right, I got a new idea. This is not exactly, I'm paraphrasing or whatever, but it sounded like then that we came in, hey, I got this new idea. What are we making? We got a new thing to make. We're going to make Pathfinder, blah, 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 blah. It's going to be great. This OGL, this, all this stuff. People may have been like, okay, well, that sounds great, but how are we going to do all that when we're also trying to publish these magazines? And then, oh yeah, funny thing about that magazine, we don't have to worry about publishing that anymore. So on to Pathfinder, everybody. Hey, Tactical Bacon. So yeah, just stopped by, caught a stream a day or two ago. What's happening now? Well, we got a what basically is happening. How if you're just coming into the stream, there was a stream today on the Call for Combat channel with Ryan Dancey, who was the architect and the guy who basically created the OGL for Wizards of the Coast back in 2000, and it was a great conversation. And so we were talking about the points that he brought up, because my conclusion from that was that the intent of the OGL was exactly what we think it is, and that it is actually what we think it is. And so that was great. And then also we had this release, or we discovered that there was an actual doctoral dissertation written on IP law, specifically about or a doctoral dissertation in the area of IP law, specifically about the OGL. So we talked about the discussion with Dancey earlier, and now we are going through a dissertation on the OGL in IP law. That's what's going on. So we are now to the readoption of the OGL by WotC. In 2014, WotC replaced D&D's 4th edition with a new 5th edition. The new edition was the result of the most extensive playtesting effort the RPG industry had seen to date. The new mechanics are simpler and enabled a more narrative form of gameplay than the constricted 4th edition allowed. Prior to the release of 5th edition, there was some confusion about whether or not it would be released under the terms of the GSL, a different license, or no license at all. Nearly 18 months after the 5th edition was publicly released, WotC announced that on January 12th, 2016, that they had released an SRD for 5th edition and that it was being made available under the terms of the OGL. The company that had created the OGL had completed a full the company that had created the OGL had completed a full cycle between 2000 and 2016. From its initial release in 2000 through its abandonment in 2008 and then its readoption in 2016, WotC returned to the use of the OGL in the face of market competition spawned by that very same license. Concurrently with its readoption of the OGL in January 2016, WotC appeared to borrow a strategy from Paizo Publishing and announced the creation of the Dungeon Masters Guild, an online marketplace for WotC powered by online publisher One Bookshelf, provides space for its customers and competitors to sell content made using the OGL. The Dungeon Masters Guild allows contributors who agree to set content guidelines to offer for sale on the Wizards of the Coast run website materials that are compatible with 5th edition D&D 5th edition using some of WotC's product identity. Right, so if you want to write something for Waterdeep, you can do it, but you got to publish it through the Game Masters Guild and follow those rules, which is cool from a fan's perspective. Difficult to run a business on, but fun, cool. People liked it when Pathfinder did it, right? In 2019, the RPG industry appears healthy and more facilitative of participation than ever before. In 2019, the RPG industry appears healthy and more facilitative of participation than ever before. Publishers are interested in selling their RPG content can choose from a variety of online platforms, including online storefronts powered by WotC and Paizo, independent retailers such as RPG Now and DriveThruRPG, and even platforms dedicated solely to selling content licensed under the OGL, which at this time of writing lists over 100 publishers offering content for sale. RPG conventions at which gamers gather to play and take place globally, with the largest crowds attracting over 50,000 attendees. The industry is dominated by two large publishers, WotC and Paizo, but an entire ecosystem of medium-sized, small, and hobbyist publishers publish material for a paying audience estimated to number in the millions. The consequences of the OGL, an overview. Let me take a look at the chat. Okay, well, then we'll look at consequences. All right. What has this done? Tactical Bacon says 6E theoretically has promise to me just because I mostly play online, but this whole move gives me mixed feelings. Well, and originally when I was looking at the 1 D&D or 6th edition content, the rule set on the morning grind, I mean, I wasn't even aware of all of course, this was before the leak. This was even before the leak, but I even wasn't aware of all the controversies surrounding the online play and all of that. And I was just looking at it from the perspective of what are these rules like? Let's see what they're doing. Are they improving them? They might be better. Let's see what they are. Then all this other stuff is going on. Yeah, yeah, I don't like the idea. We did talk about that. Isaiah Welsh says, I don't like the idea of talking to Tactical Bacon. I don't like the idea that the license can be revoked at any time. And despite that, WotC can still use my stuff without paying me. That's why OGL 1.1 sucks harder than a Hoover. There are a lot of reasons why that is. But we did talk about the transference of rights. We didn't. They did on the Roll for Combat channel. And like, how does that influence like a Star Wars OGL, a Star Wars RPG or something like that, or a Lord of the Rings RPG? And Ryan Dancey tended to say that that was not something that would happen because you as a publisher don't have even the ability to assign like the rights to Lord of the Rings to WotC. That's not even something you can do. Now, whether or not that means you can't publish under the contract because you don't own everything in there or not, something else to think about. But it did come up. Okay, so consequences of the OGL, an overview. The OGL has been regarded positively by many professionals within the RPG industry. The OGL and the D20 system serve as an entry point for numerous publishers, who begin by creating D20 system materials for use with D&D, and then further develop and deepen their own publishing lines. Clark Peterson, principal of Necromancer Games, described the OGL and the D20 trademark license as a wonderful addition to the health of the role-playing hobby. Lisa Stevens, CEO and WotC competitor Paizo Publishing, noted that the OGL and the D20 systems had inspired an explosion of RPG books, the likes of which the gaming industry had never seen before. Many publishers who made the use of the OGL to release material went through a maturation process. During the first half-decade following its release in 2000, there was a consistent pattern of publishers using the OGL in conjunction with the D20 trademark license, as WotC originally intended, to create RPG materials for use in conjunction with D&D. Over the subsequent years, many of those same publishers then dropped the D20 trademark license in favor of utilizing the OGL on its own to create their own standalone games with which to compete with D&D in the RPG market. For example, Mongoose Publishing produced 6 different games using the OGL between 2003 and 2006, including games based on Robert E. Howard's Conan the Barbarian character and Robert Heinlein's Starship Troopers novel. Trollord Games likewise started using the OGL and D20 trademark license in tandem, but then moved on to publish Castles and Crusades, a standalone game released using the OGL, which tries to evoke the feel of early versions of D&D. The Year of Living Free wiki, devoted to cataloging free and open source RPG or free and open source games, identifies 64 separate games, including D&D, that have been released under the OGL. The Fossil Bank Wiki lists 154 separate games released under the OGL. While the subjective views of OGL users regarding OGL's impact will be explored further in subsequent chapters, this preliminary overview turns to public statements made by 2 prominent figures in the industry, Ryan Dancey, the originator of the OGL, and Mike Merles, one of WotC's leading game designers on D&D's 4th and 5th editions. In a variety of different forums, Dancey has articulated his views on the consequences of the OGL. Dancey has identified a number of different rationales for the creation of the OGL. He has described its primary goal as helping to relaunch the D&D game, and expressed the views that the OGL succeeded in accomplishing that goal. He also stated the purpose of the OGL was to act as a force for change, and in that sense, I think is an unqualified success. Describing the OGL as a driver of innovation, Dancey's description of the changes brought about by the OGL can be understood as structural in multiple senses, but most saliently, he described the OGL as having altered the relationships among publishers, professional RPG developers, amateur players, and the content itself. As he wrote, the OGL changed the relationship of fans to publishers. Any person with an idea could participate in the market if they wished. It also changed the relationship of developers to publishers. Developers were free to show that their creativity using a widespread system, which also meant their talent could be more easily determined instead of having to first decipher a whole new set of notations and rules. Dancey also stated that OGL altered the delivery systems for RPG content. Prior to the OGL, other than perhaps a magazine submission, short-form material had no viable commercial market. Likewise, the idea that an electronic-only product could be marketed effectively was doubtful. Dancey described having been amazed and surprised at the number of commercial adventures that got started around the OGL, and he highlighted that in terms of getting more people into the business of publishing tabletop RPGs and more people into the role was paid to do the RPG design. The OGL broadened and deepened the talent pool in the industry. Of particular note, in light of the OSR and creation of the retro clones, Dancey wrote that as he had also had the goal that the release of the SRD would ensure the D&D in a format The release of the SRD would ensure that D&D, in a format that I felt was true to its legacy, could never be removed from the market by a capricious decision of its owners. So that, that is part of making sure that, well, there's going to be some form of this out there, even if the company that owns it completely tanks it or does something terrible. The OGL, in other words, served as an archival function as well, preserving the accessibility of the game and the vagaries of assertions of intellectual properties from the vagaries of assertions of intellectual property rights by a recalcitrant owner. In his interview for the research for this subject, Dancey took pains to make it clear that the development and realization of the OGL were the product of a team effort involving many people at WotC, but his closing words from the interview encapsulated his view of the impact. Thousands of other people took it and did creative and exciting things with it outside of the company and are still doing that today. Dancey also identified negative aspects of the OGL, D20 systems innovation. A glut of OGL crap flooded the market. I remember that. And some RPG publishers tried to shoehorn into the D20 system games which would have been better served by other mechanics. There were also organizational failings, which Dancey noted. He viewed WotC's abandonment of the D20 trademark license as a mistake. He thought the OGL itself should have been updated to address certain drafting deficiencies, the treatment of software, handling content from multiple sources, and citation of sources. And he bemoaned a lack of central authority clearinghouse, which could make OGL licensed content searchable and accessible to future designers. Ultimately, however, Dancey's assessment of the OGL was positive. I sleep pretty well at night. I think the OGL was a benefit to the industry and to players, and I think this is still generating good works. In 2008, prominent game designer Mike Merrills wrote in a blog post entitled, "Has Open Gaming Been a Success?" Merrill's assessment was somewhat more equivocal than Dancey's. He described the OGL as having some successes and some failures. The primary failure he identified was a processual one. The iterative design process embraced by software developers, which leads to the continuous improvement in software code, did not meaningfully translate into the RPG market. Merrills had hoped the OGL would lead to an active community of designers, all grinding away on D&D to make it better. But that desired result happened only in a fragmentary manner. That failure to transpose the open source process into the gaming environment is, in Merrill's view, a function of differences between software and games. RPGs lack easily defined metrics for quality, success, and useful features. Unlike software development, where the open source code process allows for rapid identification and fixing of problems, the RPGs suffer for the crippling problem that no one can agree on what problems need to be fixed or how to fix them. In Merrill's final assessment, open gaming was not a failure. It just took a different path when compared to software. Merrill's observation is a reminder that although they share some common structural elements as described in chapters 3 and 4, open source software licenses and open content copyright licenses need not, indeed should not, be judged by the same criteria. Open source software licenses are meant to facilitate, through the inputs of multiple contributors, continuous improvement of the software being designed. Since the notion of an improvement is one that is not easily transposed to creative expression, the lack of consensus the OGL resulted in improvement is not necessarily fatal to the assessment of the value of the OGL. As was discussed in Chapter 4 and will be further explored in Chapters 7 and 8, the context of creative expression, the relevant object attention for the criterion of improvement may not be the work itself, but rather the community of consumers that work and the level of participatory engagement undertaken by them. In ultimately concluding the OGL was a success, let me see what's going on in comments. Howdy, the Rocket Couch. Good to see you coming by. Good to see you. Oh yeah, talking about the licensing, the royalty amount. Yeah, it's high. It's high. I saw somebody else talking about that today and was talking about, I forget where now, but what is it may have been a YouTube comment about what typical royalty rates are and kind of in publishing like this. In ultimately concluding the OGL was a success, Merles identifies 3 interrelated factors with the following orientations: market, community, and individual. With respect to the market, the OGL and the design of 3.0 facilitated short, cheap, but eminent useful designs, which helped catalyze, in turn, benefited from the nascent use of PDF files and e-commerce platforms such as DriveThru RPG to distribute and sell OGL licensed RPG content. OGL publishers did not need to rely on printed materials, historically the main delivery mechanism for RPG content, and instead can distribute their publications to consumers by means of PDF downloads. In Merle's view, the use of PDFs to disseminate RPGs benefited immensely from the OGL. The community and individuals factors which Merle described are the sharing and training that were facilitated by the OGL. Open gaming, the indie movement, the PDF sales have made it more possible now than ever for a good GM with a knack for writing to put together a book and get it out there for others to see. Merles highlights that game designers use the OGL to swap stuff back and forth, and that sharing might be the best thing open gaming can offer designers. In Merle's view, the OGL made it more likely for writers to build and sustain a skill set that would be attractive to potential employers in the RPG industry. And Lou was talking about that the other day. Hey, let me put, if you're here, if you're coming by, I'm going to put the Discord server link in here. I know there's lots of good conversation going on, and we've got places to discuss game design and stuff like that, and in the Discord server as well. So please do come by and join the Discord server if you would like. I actually found that part fascinating as well. We didn't talk about that early on here. But did you pay attention to when Mr. Dancey said he negotiated the license from Lucasfilm to use Star Wars for a TCG and CCG? Yeah, that was really interesting. The Star Wars, the licensing stuff from Lucasfilm, that part was also fascinating. It was just a fantastically interesting conversation. Okay. The OGL, amplified by the technology of digital communications and easy online dissemination, resulted in the RPG market recruiting a far, far larger pool of talent, and there are more people today designing and publishing RPG material than ever before. Open gaming made more people into designers and publishers, and that's a good thing for this hobby. The OGL's ultimate impact in Merle's telling appears to be that it furthered and was furthered by technological-driven changes in the RPG market, reduced, along with aforementioned technological changes, barriers to sharing, and in turn facilitated the development of writing design skills among a subset of RPG player community who wanted to become game designers. And now we get to it, the mechanics of the OGL. This part describes in detail how the OGL operates, how its conditional grant of permission to use the licensed content is accompanied by terms that demarcate the metes and bounds of the permissions granted. So here we are in the meat of things. I need more water, but I don't feel like I can close the stream without taking a look at the mechanics of the OGL. In order to complete this, I don't want to return to the going through the dissertation document, but the mechanics of the OGL. This will be the one-stop shop as far as the all this information goes. So let's get into a doctoral level assessment of what the mechanics of the OGL are as soon as I get more water. All right. Thank you for staying with me. Got water here so I can hydrate again. What's going on in the chat? Oh yeah, Dancey was excellent at answering questions. Man, he could provide some answers to some questions and do so very elegantly. Yeah, Severin says Dancey's answer to my question on why now was very eloquent and professionally done. Great insight on why he thinks they're moving forward. Yeah, so he was speculating on some stuff, but even his speculation is certainly informed by a lot of industry and insider knowledge. Yeah, that's not going to fly. That's not going to fly. Let's see. All right, let's go into here. So the mechanics of the OGL. We're going to be the best educated people on the OGL, possibly in the gaming verse by the time this is over. But which is a great thing because it's so important. I mean, I may want to publish under it if it stands, which I mean I think it will, like we were talking about. Hey, why not make some 5th edition content for the worlds we're developing here? Yeah. Try the OGL 1.0 cannot be revoked, and if it goes to court, it'll be a really quick fight. Claiming Star Wars or Lord of the Rings will make it go even faster. Probably so. Yes. Okay. So this is how this operates. And so if you haven't ever actually read through the OGL document and trying to understand it, it is a legal document. There's legalese. So we're going to get into this. The analysis in this part is based on the text of the OGL, the text of which is reproduced in Appendix H. Or you can grab any other book that you've got that's D&D compatible and uses the OGL and look at the back of the book. And a series of frequently asked questions, postings made by Wizards of the Coast. The OGL, because we've got the frequently asked questions, that's come up a lot here. The OGL is in the past few days. The OGL is a relatively short document of less than 2 printed pages, consisting of 15 clauses, one of which is a copyright notice. Only a single version of the OGL, version 1.A, has ever been released. Oh, let's see where a footnote is. 164. Section 9 of the OGL contemplated WotC publishing updated versions of the OGL, but no such updates appear to have ever been publicly released. So at this time, only 1.A has ever been released. And I believe it would be, that to me is synonymous with authorized. Only, that it was released, it was authorized, and that was it. The operation of the OGL relies on 2 foundational defined terms: open game content, OGC, and product identity. OGC is defined to mean the game mechanics and any additional content clearly identified as open game content by the licensor, but excluding any PI. PI consists of 3 sets of concepts which can, at the election of the licensor, be deemed to be product identity by clearly identifying them as such. Identifying marks, so including brand names, logos, and registered trademarks, non-textual graphic elements, including symbols, designs, depictions, and photographic representations, and other game components such as creatures, storylines, dialogue, character names, magical abilities, and supernatural effects, in each case excluding any content identified as OGC. Critical to an understanding of how the OGL operates is a recognition that the OGC and PI designations are made at the election of the licensor. These are made at the election of the licensor, and that some licensors are more generous and offer more restrained, and others are more restrained in what they choose to designate as OGC. By way of illustration, imagine a publisher who releases a 50-page RPG book that contains text, including various new rules, statistics for 4 new character classes, and descriptions of various in-game personalities and storylines, and visual images such as drawings of in-game personalities and maps. A relatively generous OGC PI declaration would state that only components of the 50-page publication that are the PI are the name of the game and its logo, and the name of the publisher and their logo, and the visual images contained in the book, with all other content being declared OGC. An even more generous approach would include the visual images. Actually, Mark Tassin was talking about that on his stream last night. That if he goes forward, I mean, and that is going forward, but if the cool name RPG stuff goes forward, he thought, well, hey, maybe we could even release images if it goes large enough. Which that would be cool. That'd be cool to actually have images released under the open gaming content. So if you need pictures of goblins or whatever, the goblin picture is there, and you could actually use it too. That could be cool. A much more restrictive approach to the OGC PI declaration would state that PI consists of the name of the publisher, their logo, the visual images contained in the book, the names of the in-game personalities and their attendant descriptions, and the text relating to 2 or 4 new character classes. By means of the OGC and PI definitions, the OG enables a licensor to license content in both open and closed basis, and to use the two concepts to apply to different elements contained within a single publication. Oh, I came up with something that I was looking at earlier here. Each component of the content of a gaming product can be categorized as either OGC or PI. The distinction is crucial. As described below, OGC is licensed on an open basis, whereas the licensees are prohibited from using PI in the absence of a separate agreement with the owner of the rights in the PI. As described by Adam Jury, a game designer and commenter in the RPG industry, the OGL allows for the intermingling of open and closed content. That innovative approach to license construction distinguishes the OGL from its predecessor open source and open content licenses, which generally only contemplate a binary approach to licensing software, code, or expressive content. Either the work being licensed is licensed on an open basis or it's not. With the OGL, the dense sets of material that tend to constitute RPG products can be licensed in different ways, even if they are the same product. So, Section 3 and 4 of the OGL erect the Section 3 and 4 of the OGL erect the conditional permission mechanism familiar from open source licenses. By using any OGC, the user is deemed to have accepted the terms of the OGL, and in consideration for agreeing to use the OGL, the licensor grants a perpetual, worldwide, royalty-free, non-exclusive license to use the OGC. That's our language. Perpetual, worldwide, royalty-free, non-exclusive license to use the open game content. Sections 13 of the OGL provides for automatic termination of the grant of permission if any failure to comply is not cured within 30 days. Sections 2 and 10 of the OGL contain the share-alike and copyleft mechanism of the OGL. Section 10 requires that a copy of the OGL be included with every copy of the OGC that is distributed, which is why we've all got that in the back of our books. Section 2 stipulates that any use of the OGC must be accompanied by a notice indicating that the OGC may only be used in accordance with the terms of the OGL. The OGL applies to any OGC containing a notice that it may be. The OGL applies to any OGC containing a notice that it may only be used in accordance with the OGL. And by virtue of Section 2, all OGC must be accompanied by such a notice. C, the provisions of the OGL must not be modified. And D, no other terms or conditions aside from the OGL can be applied to the OGC distribution using the OGL. By means of Section 2 and 10, any content that a licensure has declared as OGC is permanently open, and its openness perpetuates through all downstream works that include the OGC in question. A licensee cannot revoke the OGC status of content and cannot claim proprietary rights in OGC that they have licensed. So that was an important sentence, which is why I marked it when I was going through and making notes. Any content that a licensor has declared as open game content is permanently open, and its openness perpetuates through all downstream works that include the OGC in question. A licensee cannot revoke the OGC status of content and cannot claim property rights in OGC that they have licensed. Vision asks, I wonder if any lawyers from Wizards of the Coast or Hasbro are in the chat. I don't know. I don't know. It's possible, I suppose. Thus, if a licensor A declares content X to be OGC, licensee B can use X in accordance with the OGL and can incorporate X into B's product on that basis, even if no other content in B's product is declared OGC. X remains OGC even when included in B's products, and X remains available to licensees C, D, and E to use in their own projects as products, subject, of course, to their compliance with the OGL in respect to their use of X. The use of PI is further addressed in Section 1 of the OGC. You know, I feel like what I should do is I should put a banner up here. What are we talking about right now? We're talking about the mechanics of the OGL. Well, mechanics. Talking about mechanics of the OGL. Oh, you know, I meant to have and I'm not using a ticker. I typically on these things use a ticker. Talking about the mechanics of the OGL. That's what we're doing here. So if somebody comes in, they will be able to see what we're doing. I forgot to turn on my ticker. About the discussion that we had. If you're coming in, well, I don't know where that is, but we did talk about the Ryan Dancey stream earlier on. So at the beginning of this, we looked at the talked about the Ryan Dancey stream, and now we're looking at a PhD dissertation in IP law that was specifically about the OGL. And now we're in the section on the mechanics of it. So the use of IP is further addressed in Section 7 of the OGL. OGL licensees agree not to use any IP or PI unless separately licensed to do so. Further, PI cannot be used as an indication to compatibility. And the OGL licenses are restricted from using trademarks to indicate compatibility or co-adaptability in absence of a separate agreement. WotC, now this is important, right? So this is what's distinguishing OGL content from other uses of trademarks that we talked about much earlier in the stream and that Ryan Dancey was talking about. So that's why you don't see Wizards of the Coast trademarks on the the OGL books saying, hey, this is compatible with Dungeons and Dragons. Because if you agree to the OGL, you cannot do that. That's part of this. WotC explicitly took the position that by agreeing to the OGL, a licensee agreed to limit any other rights the licensee might have to use PI with particular sensitivity regarding trademarks. It's important to note the optionality of PI and OGC declarations. A licensor can elect to designate some or none of its content as PI. If a licensor designated all of its content as PI, there would be no need to use the OGL. WotC itself elected to designate a significant portion of the content of the D&D product line as PI, but licensors who use the OGL make varying decisions about how extensively to identify content marked as PI. The remaining provisions of the OGL address mechanical and interpretive matters. Section 5 consists of representation from any licensee who contributes OGL that they own or control the necessary rights to that contributed OGC. Section 6 requires licensees to update the copyright notice contained in the OGL to include attribution for all OGC designated content and the licensee in use and licensee uses in any OGC they distribute. This results in some OGC products containing copyright notices that occupy large portions of a printed text. Section 11 restricts licensees from using the names of contributors of the OGC in advertising and marketing unless permission is obtained from the relevant contributor. License from using the names of contributors. Restricts the licensee from using the names of people who have wrote the material in advertising and marketing unless permission is obtained by the relevant contributor. Section 12 and 14 address the effects of judicial severance, enforceability, and the inability of a licensee to comply due to court order, statute, or regulation. Was the OGL needed at all? So this is a good point that we talk about quite a bit. What could we do if we did not have one? Was the OGL even needed? Go to the comments. Hey, Open D&D. Good to see you here. Joshua asks, so what would it take for creators to violate the OGL in order to be kicked out and thus forced into a 101 deal? Well, we don't know. And of course, 1.1 has not been published. I mean, we don't actually have that. We have the leak, but at the moment, nothing has changed. I mean, there are people who are making all new RPG systems to try to make them, even more ironclad and battleproof. And so all that's going on. But at the moment, there has been no change. So let's say, was the OGL needed at all? An obvious question to ask about the OGL is, why was it needed at all? The short answer is that two related factors made the OGL a compelling proposition for both Wizards of the Coast and its audience. First, and still is, the ambiguity involved in trying to determine the extent of copyright protection for RPG game material. And second was the perceived history of TSR, Wizards of the Coast predecessor as owner of the D&D game, as an aggressive enforcer of intellectual property rights. Both aspects of that short answer require further explanation. It's sometimes taken as axiomatic that copyright law does not protect game rules. As Bruce Boyden has noted, copyright law has developed a very simple black and white black letter rule. Games are not copyrightable, though he stresses that it is a rule that begins to fall apart on closer examination. Similarly, Pamela Samuelson has noted that U.S. jurisprudence contains a series of cases holding that games, rules, and tactics cannot be protected by copyright law, though she highlights that the cases are quite spare in analysis, and that none of them offered any explanation as to why copyright did not protect games and rules. Boyden states that the origins of this rule against copyright in games are lost in the mists of time, with even the earliest cases referring to the rule without discussion as though it were obvious. While the origin of the rule may be obscured, both Boyden and Samuelson conclude that the rule that games are not protected by copyright is justified and consistent with the proposition that copyright law does not protect systems or methods of carrying out an activity. For the latter proposition, numerous authorities can be identified. As Samuelson notes, the U.S. Supreme Court decision of Baker versus Selden involving a plaintiff who unsuccessfully sued for infringement of the copyright in his book describing a bookkeeping system is often cited as an authority for the notion that U.S. copyright law does not extend to systems of methods or practicing an activity. That notion was ultimately codified in U.S. copyright law. What is that? 17 U.S.C. section 102B, is that the way you read that? Which provides that in no cases does copyright protection for an original work of authorship extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery. In Commonwealth jurisprudence, similar authorities for the proposition that systems and methods cannot be protected by copyright are found in the English case Holland-Rank versus Truswell, which held there was no copyright in a sleeve chart used by tailors. And the Supreme Court of Canada decision in Cuisenaire versus Southwest Imports Limited, holding the plaintiff's method for teaching mathematics using colored rods was not a work for the purpose of the Copyright Act, and noting that carrying out the method for teaching mathematics described by the plaintiff constituted only the use of the plaintiff's ideas, as well as the Copyright Act in Canada itself, stating that using any method or principle of manufacture or construction does not constitute infringement of a copyright in a work. In the Cuisenaire case, the Supreme Court of Canada, so we are getting some information on other countries here, the Supreme Court of Canada approvingly quoted from an Australian case and concluded that a person who carried out the instructions in an instruction manual could no more infringe upon the copyright in that literary work than would a person who made rabbit pie in accordance with the recipe of Mrs. Beeton's cookery book. One might analogize that the rules of a game to a set of instructions or systems for playing the game, so conclude that copyright protection does not extend to game rules. Samuelson regarded the exclusion of games from copyright protection as consistent with the rule of excluding systems from copyright protection, which she explains is critical for preserving the public domain, promoting the ongoing creation and dissemination of knowledge, simulating competition and innovation in the workplace, and maintaining a proper balance between the rights of authors and the rights of the public in international intellectual property law. On Samuel's account, the rule against copyright protection in systems played a role in maintaining a sphere of activity free from copyright concerns, illustrated by examples such as performing accounting calculations, cooking rabbit pies, and teaching mathematics using a system of colored rods, each informed by the description of the system, but not infringing whatever copyright might exist in that description. Bowden's conclusion is premised on the notion that systems are shells into which the user pours meaning, and that the game qua system is best understood as a mechanism for facilitating expression by the players, but does not itself constitute protectable expression. Assuming that the statement games are not protected by copyright is true, why would a copyright license be required in order to permit anyone to reproduce or otherwise make use of game rules? Because, as alluded to in Boyden's statement first noted at the beginning of this part, the abstract rule that games are not protected is complicated to apply in practice, with many aspects of any particular game occupying an ambiguous zone between protected expression and non-protectable ideas, systems, and methods. While a game may not be protectable by copyright, the various means by which the game is expressed may very well be protected. And that comes down to the difference between what is a mechanic versus the expression of the mechanic, right? We've talked about that a lot. This doc, Open D&D says, this doc protects the entire class. This gives the lawyer's framework. Amazing. This is an amazing document. It's crazy that also we have this, like I said, the emergence of this document, this dissertation, as well as Ryan Dancey's interview today, are just amazing, important information to this. And it's just been incredible. I mean, how great is it that we have this dissertation? Somebody wrote a dissertation on the OGL. I was also not supposed to be doing this as long as this today. I was going to take the night off. Tomorrow night I'm taking off. We do have the morning grind in the morning. I'm going to be unboxing the Hero Quest Mage of the Mirror tomorrow on the stream. I was planning on doing something on taking the night off too, but hey, I'm into this now. So it sounds like, and now my eyes are starting to blur. So maybe Kyle says, is this dissertation posted out there on the web? Can we link to it for people to find? Yeah, you can definitely do that. I posted a link to it in the Discord server. We'll have to find it again. Let me put the Discord server link for people coming in. It's in there, but also if you just search for the name of this, you'll find it. I found it very easily. Somebody can probably find that faster than I can right now. But yeah, this is like essential reading for anybody who's considering open game publication or just game publication in general, right? So we're coming up upon this incredible difference between the game itself and the expression of the game. Boyd notes that the constituent elements of a game, such as the rule sheet, the board game, and the pieces, are capable of being protected by copyright. Put differently, while game mechanics are not protected by copyright, the particular form in which the rules are expressed may be protectable, assuming the satisfaction of other prerequisites for protection, such as originality, and subject to other limiting rules, such as the merger doctrine. As are other elements of the game, such as illustrations and graphics, elements on game boards. Video games offer particularly thick examples of games. And few would question the proposition that software code, on-screen images, including depictions of characters, and even plots of video games can be protected by copyright. As Boyd has highlighted, the uncopyrightable core of a game consists of the system that underlies the game and the playing of the game itself. That being said, the analysis involved in drawing distinctions between unprotected ideas, unprotected game mechanics, unprotected merged expression, and protected original expression is a convoluted, even arcane one, and it's not clear how plausible it is to expect a non-specialist to apply in the context of RPGs. And as noted above, RPG rulebooks routinely run to the hundreds of pages that contain lengthy articulations of the notionally unprotected systems which make up the game. Disentangling the unprotected rule from the hundreds of words and accompanying charts that express the rule is not a task that is easily accomplished, and is not susceptible to a process that would produce unambiguities. or unambiguous determinations upon which everyone would agree. This is exactly the situation that Ryan Dancey was trying to resolve. He talked a lot about being in legal gray zones. And if you're in a legal gray zone, not a lot happens there because nobody is sure what their exposure is going to be. So you want to stay out of a legal gray zone. So he was trying to create this ironclad and bulletproof open gaming license to eliminate exactly what's being talked about right here, to eliminate all of that so that everybody knew exactly where they stood and could do what we were supposed to be doing with the open gaming license. This is exactly the situation that the open gaming license is supposed to resolve. In addition, much RPG material is extraneous to the rules in any event, consisting of images, maps, and lengthy expository text detailing storylines, characters, monsters, and foes, and other background information about the setting in which the games take place. Even the most austere application of games are not protected rule would not include the extraneous, or as some RPG players call it, fluff, content from the ambit of copyright protection. We've got an extensive footnote on the protection of games. WotC cited confusion and uncertainty in its explanation for its rationale for the creation. WotC cited that confusion and uncertainty in its explanation of its rationale for the creation of the OGL. Can game rules be copyrighted? In the United States, the rules of games cannot be copyrighted. The law of different countries, but most countries are signatures, to the Berne Convention on Copyrights, and under the terms of the BCC, the rules of games cannot be copyright. If you have questions about your ability to apply the copyright law to a game, consult your legal counsel. Why does every RPG product I own claim a copyright for the publisher? RPGs are more complex than just rules for games. A typical RPG includes substantial material that is not rules for a game. The line between copyrightable portion and uncopyrightable portion of a particular product is very blurry under a U.S. copyright law, is left to a court to interpret in the event of a lawsuit. What good is a copyright license for open games then? Even though portions of an RPG may not be copyrightable as an idea or as a rule, the actual text used to describe these rules is copyrightable. In addition, all the material surrounding the non-copyright portion is protected by the copyright law as well. The copyright licenses used in open games ensure that no matter where an individual judge might draw the line between copyright and non-copyright, you can be sure that you have the freedom to copy, modify, and distribute the work. Removing this gray area creates a safe harbor that publishers can use to shield themselves from litigation. The safe harbor is an important component to the commercial viability of open games. Without it, most rational publishers would not attempt to use a shared rule system out of fear that someone someplace would sue them for copyright infringement. Deliberate removal of the gray area of the law. Another very valuable right you gain from an open game is the right to make a derivative work based on somebody else's copyright. Without that, you cannot legally make and distribute a derivative work. Since RPGs are often self-referencing, meaning you can use one part of the RPG to indicate how another part works or intersects with other players or interacts with other players during the game, RPGs are essentially chains of linked derivative works. By giving you the right to make a derivative work, the open game license allows you to extend or modify those chains as you see fit. WotC also alluded to the history of aggressive copyright and trademark enforcement by previous owners of D&D, stating that reliance on an informal agreement among publishers would be viewed as too risky by many RPG publishers who possessed relatively modest financial resources and would be unwilling to run the risk of potential ruinous copyright disputes. The use of the OGL meant that the creators and publishers could rely on a formal, explicit agreement describing how to use copyrighted material owned by others without triggering lawsuits or threats of litigation. They wanted OGL creators and publishers to be able to rely on this formal, explicit agreement describing how to use copyrighted material. The need for the OGL was framed by reference to implicit communal understandings derived from the nature of RPGs. Most role-playing games, for example, are based on the implicit assumption that people using them will create their own content in the form of adventures, characters, and even whole campaign settings. However, few commercial role-playing game products provide a license of sufficient rights to allow the purchasers of those games to distribute the content they create using the frameworks provided by the game system. The open game concept addresses this problem by explicitly providing such rights. It has been established an established feature of RPGs since their inception, and that would make use of new content. Prior to the advent and widespread open game licenses, there was no practical way for that kind of material to be legally and widely distributed. Ryan Dancey has also stated that in his view, the heart of the OGL is that it gets rid of the legal gray areas, which is what we were just talking about, and which have plagued RPGs from the beginning. It has always been dangerous to publish RPG content that isn't derived from an entirely new game system. The OGL tears down that ambiguity and legal risk and says, if you do X, Y, and Z, you can do A, B, and C totally legally. That locked a tremendous amount of capital to invest in game publishing. Unlocked a tremendous amount of capital to invest in game publishing that otherwise would never have been committed due to legal risks. One commenter described the OGL as a concession that was really no concession at all, because it granted no rights or privileges to third-party publishers that they did not already have. Who was that said that? 205. Andrew Lispand, Legal Issues in Gaming, the Open Gaming License, published in December 19, 2012, Tales from the Gamer Viceroy blog, found online there. Nonetheless, in view of that same commentator, given the history of litigation and threats of litigation in the RPG industry, the OGL served a distinct purpose. The OGL is nothing more than a license to breathe. But for a community that thought they could not breathe without permission, the OGL serves as an important purpose. It lets the gaming community feel safe about publishing game content without something that had a long history of being quasi-dangerous game. That description of the OGL as a license to breathe is consistent with the description of the concept of a license that was set forth in Part 2A of Chapter 1, the license being the manifestation of the licensor's election to waive or forbear from any enforcing the licensor's right to exclude others. And as described more fully in that earlier chapter, we can understand the licensor's covenant not to sue, not just as a forbearance on the right to exclude, but its inversion, as a positive act of inclusion and community creation. These aspects of the OGL will be further described in Chapter 8. Our next subject is the open game license and open game license. And okay, and then we get to conclusion. Okay, well, so is the open game license an open content license? So we got some questions here. Let me go over here. So Backstabber 590, is this the leaked? Is this on the leak of the OGL? Well, we did a stream on the actual leak. What was that? No, that was Monday. We did a stream on the leak on Monday. This is not. This is a stream on the discussion that Ryan Dancey, the creator of the OGL, had on Roll for Combat earlier today. We discussed that at the beginning of the stream, and now we are looking at a dissertation that was written in the field of IP law for the grant of a PhD in IP law that was specifically written on the OGL. Imagine that. Imagine that. This was a 2019 doctoral dissertation on the subject of IP law, specifically about the OGL. What a perfect find. Yeah, Discord is a better place for conversation, extended conversation. And I hear people talking about stuff in Discord. If we need other stuff in Discord, I'm still working on Discord, but I haven't been able to do many things over the past 4 days since this leak. We could certainly just have a place for OG. If there's not already a thread for just OGL talk, I mean, we can make one. Okay, so let's go down here and say, is the open game license an open content license? Because we went over at some point in this, a lot of info on what an open content license is and what its definition is and what it has to include. Subject to jurisdictional qualifications relating to moral rights, the OGL qualifies as an open content license as defined in Chapter 3 of this dissertation. We could use those same qualifications to find out if the 1.1 is or is not. It displays all the necessary features and none of the disqualifying features. This is the 1.0a. An important caveat is that the OGL does not contain a waiver of moral rights or otherwise expressly address moral rights in any fashion. As a result, the OGL does not qualify as an open content license in those jurisdictions, such as Canada, that vest authors with moral rights. The OGL does unequivocally qualify this as an open content license in the United States, the jurisdiction in which WotC and its primary competitors in the RPG market are headquartered, and in which most users of the OGL appear to reside. The OGL is properly categorized as a copyright license as discussed in Chapter 1. It is a conditional grant of permission in respect to an exclusive right possessed by the licensor, and the permission granted by the OGL is with respect to copyright-protected works, the SRD. The OGL has a stable form, indeed. Indeed, it has only the single iteration and is non-exclusive and available for take-up by any interested party who wishes to and agrees to abide by the conditions of the license. Earlier, I made note of the fact that the grant of the permission contained within the OGL is perpetual. Here is the use of that word. That's why I highlighted here. The grant of the permission contained within the OGL is perpetual, and the permission can only be terminated for breach of license terms. We'll say that again. The grant of the permission contained in the OGL is perpetual, and the permission can only be terminated for breach of the license terms. The OGL does not expire or limit the number of uses which can be made of the content to which it is applied. No royalty payment or other form of compensation becomes owing as a result of the use of the OGL licensed content. And the broad definitions of use, distribute, and derived materials found in the OGL are sufficient to include all of the activities contemplated by Wiley's 5 R's: retain, reuse, revise, remix, and redistribute, which you already went over earlier in this stream. The OGL does not contain any restrictions on commercial use or otherwise impose restrictions on the use of the licensed content that pertain to the nature or characteristics of the licensee or the activities being carried on by the licensee. The strongest argument against categorizing the OGL as an open game content license is that it contains certain restrictions on Sections 7 and 11 that unacceptably hinder the rights of OGL licensees. Section 7 of the OGL prohibits a licensee from using any product identity, as we talked about, including as any indication as to compatibility, except as expressly licensed in other independent agreements with the owner of each element of that product identity, and obliges licensees to not indicate compatibility or adaptability with any trademark or registered trademark in conjunction with a work containing the open game content. That's why we all just say compatible with 5e, right? Except as may be authorized in a separate license. Section 11 of the OGL restricts licensees from marketing and or advertising the open game content using the name of any licensor or open game content unless separately permitted. However, neither of those restrictions serve to render the OGL a closed license. The first because it's merely a mechanism within the license that particular licensors may elect to use in a relatively more open or closed ways, and the second because it restricts only ancillary activities that do not impinge upon the core usage rights in respect of the copyright-protected material. The restriction on the PI in Section 7 does not violate the requirements identified in Chapter 3 because of its optionality and flexibility of the PI designation. A licensor can elect to designate none, some, or all of the licensor's content as PI. And while different designations may make particular products or instances of use, of the license more or less open, the mere fact that the OGL allows such designations to be made does not render the OGL a closed license. Similarly, the restrictions on the use of trademarks and compatibility statements contained in Sections 7 and 11 of the OGL, which prohibit the licensee from carrying on marketing and advertising related activities using the name of the licensor, does not impact the licensee's rights with respect to the use of the licensed copyright protected content itself. That would be the SRD. That does not impact your rights with respect to the use of the licensed copyright protected content itself, the SRD, and hence does not affect the 5 R's needed to qualify as an open content license. Whew, what's our conclusion here? Let's go to the chat. Finally, the conclusion. Yeah, I know. So that was it. Right. Yeah. So basically, though the problem is that things with copyright tend to be more blurry than what a lot of people think, and rulings are not as consistent as you would hope. And this was an attempt to stop that. Yes. Yes, Isaiah. There's a lot of people here, and Piano as well. Thank you. Isaiah says, thank you. That's exactly what I've been saying. The only way to terminate the license is to breach it, not termination via unauthorized. GCW 1978 says, I feel that this is definitely something I've been getting from the various attorney vids I have seen this on, with there being a could go either way vibe. I did not find this. It was another thing that came from Roll to Win Combat. Roll to Win Combat is just dominating it over here. So I did not find this. They did a video. They found a YouTube video with the author of this dissertation talking to somebody about it on combat law. Oh, yeah. Roll to Win Combat says I found it. Roll to Win Combat has been dominating it. So I watched the video. Roll to Win Combat was watching a YouTube video about on contract law, on a contract law channel, I believe it was, where this person was talking to that person about the OGL. And that was fascinating. And so then I went and found the dissertation, Roll to Win Combat probably had it in there, the link in the description. And so I downloaded it and I started analyzing it. So Roll to Win Combat has been dominating this as far as breaking all of this. Yes, Steve is a hero. Steve, you are a hero. You're all of our hero. Who is the author? Here, I'll scroll back up. So if we can find him, I mean, I'd like to interview him. The author is, we were trying to figure out how to pronounce that name, but Roberto Tarantino. People were telling me about the pronunciation of the first name earlier, but I'm too tired now to remember. So the conclusion. Well, where was I? Oh, I lost it. No. Oh, we're way past that. Sorry, guys. I believe that's all the history. Looking for. I shouldn't have scrolled up. This was our purpose. Okay, so now I think we're getting right here to the conclusion. So this conclusion right here? Yes, the conclusion. All right, here's where I was. So as a precursor to the fieldwork portion of this research project, this chapter has reviewed the origin and history of the open game license. The open game license began as an effort to revitalize the market for a desiccated brand and resulted in a burst of activity and creativity within the role-playing industry, with many sustained and unpredictable results. This chapter has also described how structural aspects of role-playing games lend themselves to certain creative practices by RPG participants which foreground dialogue and relationships, and how these practices bear commonalities with other creative activities, particularly those that occur in an environment of digital connectivity. The analysis also examined whether the OGL was required and examined why the history of RPG industry and inherent complications in the copyright analysis of RPGs means the use of the OGL was at least an advantageous business strategy. With reference to the I can't even talk now, of a success for open content licensing and identified in Chapter 4, we find the OGL was introduced in an environment that seems particularly receptive to successful employment of open content licensing. Wizards of the Coast, through the offices of Ryan Dancey, had a pre-distribution in favor of the open goals of the open source software community, a sublimated need for immediate financial returns, expecting, in alignment with the predictions of the so-called SCAF effect, that initial openness, we learned the SCAF effect here today. That SCAF effect, that was the idea that it was, that by doing this, that was going to sell more D&D books and fuel D&D. In initial openness would yield financial rewards to the future. A willingness to establish and maintain initial openness would yield financial rewards for the future. That's the SCAF effect. A willingness to establish and maintain an open community, a willingness to allow third parties to take on designs with marketing efforts, and a desire for maximal dissemination. RPG game materials are modular, non-bound, expandable, inexpensive, and to create, easy to reproduce, display transient utility, ease of consumption, and replayability. There appears to have been at least a conjecture, if not a settled belief, that the RPG market displayed network effects. The OGL was used in the context of an existing RPG community whose members displayed predispositions to actively create additional material and value idiosyncrasy and improvisation. The RPG market itself is also displayed a number of the indicia. I've never seen that word before or pronounced it. Indicia, I guess, maybe. Identified in Chapter 4. It was a market featuring a dominant, if diminished, competitor. The market for D&D had recently been depressed due to an advent of competing gaming options, and it featured a consumer that delayed an appetite for multiple iterative variants of the same content. Also of significance was the capacity of the market to sustain a dual license approach in a variety of ways. WotC and Ryan Dancey were explicit in noting that their belief of the value in D&D was found primarily in the trademark and brand, and only secondarily in the copyrighted protected material. While the OGL offered free access to stripped-down versions of D&D's source code, printed materials bearing the D&D trademark and brand were sold for premium prices in hardbound books. Even the copyrighted protection material was licensed on a dual basis, which was designated as product identity and was not licensed on an open basis under the OGL. Wizards' approach indicates that the presence of rights in a trademark or brand as the repository of value may be required or at least desirable when disseminating any means of an open content license. Let me say that again. Wizards of the Coast approach indicates that the presence of rights in a trademark or brand as the repository of value may be required or at least desirable when disseminating by means of an open content license. However, while the presence of such a brand was certainly true for WotC and D&D, it is less obvious the case for other OGL publishers, a matter that will be discussed in Chapter 8. Having described the context within the OGL was created and outlined its operation, the following chapter of this dissertation explores the data obtained in the field elements of the research data. That data is then analyzed using a theoretical framework developed in Chapter 1 through 4 in an effort to develop a richer account of what and why open content licensing can be successfully used in conjunction with creative cultural expression. That's the purpose of this dissertation. So all of this stuff, the purpose, he's doing a research project to see this. How can you decide if a open game license has been successful in the context of creating this community and spurring all of this creativity? And that's the framework here. So this is the field work. I'm just going to scroll down to make sure I didn't have a highlighted phrase or word here as we get to the end of this, because I was looking for key words when I was doing my initial notes on this dissertation. Let's see. I don't see highlights. Let me scroll up slightly here. What is this heading? Oh, this is a long section. Community motivations. Okay. So that's analyzing the motivation of why to do this, but we've already, and why to potentially do this. We've covered a lot of that in the context of Wizards of the Coast specifically. Other forms of IP protection, infringement. This is a summary of fieldwork. Chapter 8. Chapter 8, successful use of open content licenses for creative expression. So we're trying to decide, that's the purpose of this research, like I said, to find out whether or not this is a good vehicle for creative expression, specifically studying the OGL. So we did refer to Chapter 8 quite a bit, saying that stuff would be in Chapter 8. But I think that I didn't find material on my first pass that was in this section that was immediately relevant to what we are talking about here. So we should be coming to the end of this. There's probably a giant. Oh yeah, we use. Let's see, right? I figured we were about to be getting to different kinds of appendices. Concluding thoughts. Conclusion. We're now to the conclusion of the entire thing. So that's all of the research summary and stuff like that. Bibliography. Boom. How about that? All the way through it. Kyle says, would this dissertation have any legal weight? Well, this dissertation is not a legal ruling. It is not a case. It's not anything like that. but it is all of your research and, understanding of the way things have been, the way terms are used, what this is. This is, how we, this is all your references and stuff like that. Yeah. Yes, you can find it. Okay. So, yes, I've been on this. That took 3 hours. So this wouldn't actually take 3 hours. So it was the initial conversation about Ryan Dancey, like 45 minutes or something like that. I was going to take a break tonight, but because I feel like this has just been epic. I think some of this probably needs to be clipped. Because other people may want to study certain parts of this. I think this will be a really useful part, really useful for the OGL community, because people will definitely listen to something. There are a lot of people who would listen to this who would not go and read that dissertation. So that's a major advantage of long form. I don't know what you call this, live streaming and stuff like that. So hopefully it will be advantageous to the community. I don't know that I have a whole lot more to say on this part of it. Now, I suppose I will if there's a release from Wizards. But, I've come to the conclusion that to summarize my point from the beginning, after all of this, going through this dissertation and listening to Ryan Dancey, I came to the conclusion that the OGL was intended to be what we all thought it was, and that it is what we all thought it was, which is great news. So now that has cleared up to me the ambiguity that we have potentially had over the past 4 days. Any ambiguity that all of a sudden sprang up in comments and everything like that. For me, at least, that ambiguity is resolved in my mind, and it's the way that we thought it was. Now, what Wizards of the Coast can do next, I guess that'll be the next big thing, right? Thank you so much. Hats off. Thank you, Emily. Toast everybody. Thank you so much for being here. Being here, and if you find this on replay as well. So my 2 most attended live streams were where I read the 1.1 legal document, and here when I was reading and analyzing a doctoral dissertation, and that's just fun. So thank you. I says, I'm subscribing to you after all your efforts today. Great content. Thank you. Really, please do hit the subscribe button. That would really help out. That would really help. And also, if you want to come by the Discord server, I agree, Ryan. Ryan says the ball is in their court. I think the ball is in their court now. I think that's a great way to describe that. The ball is now in their court. So we will see what happens. That'll be the next big news, I believe, as far as I'm concerned. Tomorrow morning, I will be on the morning grind, 9:30 a.m. Central. We'll be unboxing Hero Quest, the Mage of the Mirror. I just got that in. We will do an unboxing and see what all is inside that box. But then I may be posting YouTube videos and other clips. I do have some other YouTube videos as far as about Dungeons and Dragons and the status of its brand and things like that. I'm not going to live stream those. I'm just going to record those and put those out. And you will probably be seeing clips from this live stream appear on the channel as well. But I will be live streaming tomorrow morning, and then I'll be taking all of tomorrow off after I do the live stream tomorrow. I got to clean house. I'm taking it off, but I got to clean house and do other things. Thank you so much. Thank you so much. Thank you so much for being here. You guys give me energy. I hope I give you energy. Let's go back. Let's make sure that 1.0A stands. Later, everybody. Bye.